motions calendar, and it appears that we have a add-on calendar for this morning. Position number 1, Christina Anderson.
Good morning, Your Honor. Brenda Rothman here. That's going to be a plea this morning.
Oh, very good. Good morning, Ms. Rothman. Do we have the paperwork ready for that?
Yes, you do.
Okay. We'll go ahead and get that completed as soon as I can finish the calendar, okay?
Thank you.
Position number 2, Willie Colbert.
Yes, Judge, that is my case. Your Honor, we did file a motion for continuance. In this case, the Trooper Chadwick Clark is on extended leave until after May of this year. He's on maternity leave. In addition, Judge, a review of the record showed that no particularized motion had been filed in this case, at least from what I can see. So that would be the state's announcement, is that we filed a motion.
Okay, and this is Mr. Colbert. Have you spoken with Attorney Collins?
I have not.
Okay, well, given that it's after 9, state's calendar's been called, no communication with Sean Collins, the request will be granted. We'll put it for some time in June, I imagine. Okay. Position 3, Carlos Hoyos. Yes. Okay, very good.
So with regard to the state, I didn't see any motions filed, so I just need to know what motions filed.
So we filed a motion, and I did send copies to go to the court's attention, I think, Mr. Randall, and also Ms. Gathia.
Okay.
You know, those, I knew there was got to, and I've got copies to the law court.
So then my announcement would be that we haven't subpoenaed any witnesses because no motions were filed that I can see in the record.
Well, again, that's not, so I'm not quite correct. We did file a motion.
Hold on, what, no, I just want you to be heard. So for you to be properly heard, I need for, and this to be on the record, I need for you to come on up to the, I'm happy to hear you, counsel. I just want to make sure that everybody can hear you.
This mic right here? Okay.
All right.
So I can go back and look at my email records, but Judge, we filed the motion with through the Odyssey system, not seeing that it had been properly docketed or filed in with the clerk. I went ahead and sent emails to Ms. Gathia and to the court, and I emailed copies both to the court and to the state. The particularized motion. There's also a discovery issue, an outstanding discovery issue as well. I emailed those motions, and then I also emailed the court to find out, are we still having court today? Are we ready to proceed on the motion? And I was told, yes, we are. So we're here and we're ready for that motion. And it's of course the state's job to know what they need to do to answer our motion to suppress and dismiss.
I prepare for motion calendar if I go through Odyssey to determine whether any motions have been filed.
Excuse me, Your Honor. I'm sorry, I'm having a little trouble hearing Ms. Waldrop.
Yes.
Okay, we turn the mic on. Good morning, Ms. Greenhouse.
Thank you.
I hope
Good
you're
morning.
well today. Thank you for
Thank
being here
you.
for us.
Thank you so much.
So, Your Honor, the way that the state prepares for its motions calendars in terms of sending out subpoenas and preparing for the motions is I go through Odyssey to determine whether or not motions have been filed. In this particular case, I went into Odyssey, did not see any motions filed. I think defense counsel just stated on the record that they were not properly filed through Odyssey. And so he emailed them over to a prosecutor. But I didn't see anything filed. The discovery issue, I'm not sure what that would be because I did share media with Alan at alanjlevine.com.
That's me.
Yesterday, so hopefully you received that. But there being no motions in Odyssey as part of the record, the state did not, was not prepared to go forward today.
It was just, that's not correct. We did file a motion through Odyssey. For some reason, it didn't acknowledge that it was served. When I noticed that it wasn't being served, that's when I contacted Ms. Gathia and the court to say, hey, I filed these with Odyssey. Here are the motions. And then I also asked the court, are we going to proceed today because of that? And I was informed, yes, we're to be here today. We were noticed to be here when this, last time we were, present in, I guess, the, calendar call. We were told to be here on the 21st. We've, again, filed the motion. I communicated with Ms. Gathia. We were told to be here and we're ready.
And Your Honor, I think it's great that he contacted the court. I didn't get a phone call asking it anything about whether or not we were going forward. And so, I mean, that's great that he contacted the court, but
Well, Ms. Gathia too.
Okay, so what I want to do is I want to resolve it, okay? So I understand both positions. So, I understand that the state's not prepared to go forward today. You know, we've been having everybody knows we've been having issues. And if you saw me earlier today in court, I was still not able to properly get on my computer and things of that nature. So I am giving leeway because of the issues that we're having. But I would also want to go ahead and move it forward. I am going to be here tomorrow. I'm going to be here pretty much all next week. So if you all can give Ms. Waldrop enough time to at least investigate to see if your people are available possibly next week, I could fast track this and I could make time for you around your schedule to be back down here so we can take care of this. So if you all wanna speak on the issue after and come up with a date possibly that that we could reschedule this in the very near future. I think that would be helpful.
Yeah, I think the issue will also be my client's travel, because he has to travel for work as well, but I will certainly talk. And I guess the other direction I'll need to know is who's the prosecutor I'm dealing with, because I was told it was Ms. Gathia.
Okay, well, we'll do that today, okay?
Okay.
So I'll have you talk with everyone you need to talk with today. We'll try to accommodate both of you. And I understand, Ms. Waldrop, that you have to get in touch with whomever you need to get in touch with, and they'll have to make plans to be here. But I will do as much as I can to help accommodate everyone. And I'm sure that's going to throw back on my staff also, because we do have a number of things I know going on next week with jury trials and all.
yes, Judge. And if I could get a copy of those motions today, then I'll be able to determine if I need 2 witnesses versus 1.
Okay, and I'm happy to give you a copy of what I have
Okay.
up here.
Can you
And-
email it? You want it in hand or email?
Is that the judge's copy? Because if
I've got additional copies I can
Okay,
give you.
well, if you could just give her a copy, but you can give that back to me when you're done, Ms. Walker. Okay, so you all will speak on that and just come to some agreement amongst yourself, okay? All right, I appreciate it. Position number 4, John Keeley.
Your Honor, basically, we're here for Mr. Kelly. He's present beside me. We're here on a motion to suppress. We'd be ready to proceed at the court's convenience.
Okay, and spell the last name for me.
Last name is Kelly, but it's spelled K-I-E-L-L.
Okay, I just want to make sure I got it right. Good morning, Mr. Kelly.
Your Honor, unfortunately, I have an announcement on that case. We were unable to serve Officer Daxton. The software indicates that he's employed by Alpharetta Police Department, but he actually now works for Forsyth County Sheriff's Office up there. We emailed a subpoena to Alpharetta last week and became known yesterday morning that he no longer works for Forsyth. We tried to serve him all day. He was on night shift in Forsyth County. And so the state will be asking for a reset in this case. This is the first time that it's come up on the motions calendar.
And the key word is unfortunate. This is certainly unfortunate that, Mr. Kelly and I, we filed motions, we prepared for this. Case has been on motions calendar, and I object. And also it's important to note that this individual was not served, and the law is extremely clear on what is required under OCGA 17-825, absence of witness as grounds for granting continuance in all applications for continuances upon the ground of the absence of a witness. It shall be shown to the court that the witness is absent, that they have been subpoenaed, that he does not reside more than 100 miles from the place of trial by the nearest practical route, that his testimony is material, that the witness is not absent by the permission directly or indirectly of the applicant, that the applicant expects he will be able to procure the testimony of the witness at the next term of court, that the application is not made for the purpose of delay, but to enable the applicant to procure the testimony of the absent witness, and the application must state facts expected to be proved by the absent witness. There's another code section that deals with subpoenas. And generally,
I don't mean to cut you off.
Yes, Your Honor.
Cleaver.
Yes, sir.
I'm gonna hear your entire argument. Let me get through my calendar first.
okay. I mean, I was getting ahead of myself, maybe.
No, you're fine. Yeah, so, but, Mr. Birch, what I would suggest to you is that before I do hear arguments, that, that you all may try to want to work this out possibly. Because I'm not sure what you're gonna say or what he's gonna say, but, I'm gonna give you the opportunity to see if you can work it out before I have a hearing on this morning, okay?
Thank you, Your Honor.
Yes, Your Honor.
Position number 5, William Moore.
Birch on that, we'll be ready.
Okay,
Yeah, and the state's ready. The officer's en route right now.
okay.
Yep.
All right, so let me go ahead first and, oh, we do have the add-on calendar, I'm sorry. Position number, the only position, Thomas Uletti. Is that also, Mr. Cleaver, is that your case?
I'm sorry, Your Honor.
I have an add-on calendar, Thomas Uletti.
Yeah, that's scheduled for this afternoon at 1:30 in Mr. Roulette's case.
Okay, it's on my 9 o'clock calendars. This,
Yeah, I understood it was the 9 a.m. as well, and Officer Postma is here for that.
I had him for 1:30 this afternoon. I
okay,
can give Mr. Roulette a call though, Your Honor, and get him down here if needed.
okay. Are you ready, to move forward on that one?
I would be.
Okay, so see if we can get him down here, this morning. I'll give you that opportunity, okay? All right, thank you.
We did send him an email and tell him to come this morning. We sent
Okay.
that attorney an email to let him know that client wants to be here.
Okay, and did you just send it this morning?
No, he said, we talked with him yesterday. Miss James talked to him, emailed with him and told him, no, council at 1:30, we are to be here. All motions are to be heard at 9 o'clock.
Okay, well, we'll see if we can work it out, okay? Is there anyone that I missed? Okay, so let's go ahead and take Ms. Rothman's motion first. And then once we do that, I will give Counselor an opportunity to speak, and then we will proceed with the matters that we have. Okay, and do I have plea paperwork for position number 1, Ms. Anderson? Well, I don't have plea paperwork, I'll just say it that way.
Still waiting.
Your Honor, it was submitted through DocuSign. It should be in the state.orca at Fulton County GA email. That's where it would have gone.
Yeah, I don't need that anymore. Well, no, hold on, let me go ahead and just, grant this. Good morning, Miss Anderson. I hope you're well this morning.
Good morning, sir.
Can you raise your right hand for me, please? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. Thank you, ma'am. Whenever you're ready, Ms. Waldrop.
Thank you, Judge. Ms. Anderson is pleading to one count of reckless driving and one count of speeding. The failure to maintain lane will merge. On the reckless driving, the negotiated sentence is for 12 months to serve 2 days, credit for time served of 2 days, balance probated, for Ms. Anderson to pay a $300 fine, complete 40 hours of community service, an alcohol and drug evaluation, and any treatment deemed necessary as a result of that evaluation, risk reduction, and one victim impact panel. With respect to the speeding, the negotiated plea is for a $450 fine.
Ms. Rothman?
Thank you, Your Honor. Yes, that's the negotiated plea as we understand it. We do, just to let you know a little bit about my client, she has been working in commercial HVAC, but as of this arrest, she has been unable to work in that and is continuously looking for work. She spent 8 years in the Army and did 3 tours in active duty in Afghanistan and Iraq. She was an ammunition specialist. We ask you to accept the plea as negotiated.
Ms. Anderson, it's my understanding that in case 21 CR 006610F, you wish to plead guilty to reckless driving and speeding. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as negotiated, Ms. Anderson. Let's see, as soon as you complete the terms, I will have the probation terminate. So as soon as you get it done, the sooner you won't be on probation and the sooner you won't have to pay those fees, okay?
Yes, I understand. Thank you, sir.
Okay, we will, if we have not already, we will get you and Ms. Rothman where you need to report to probation. I ask that you report within the next 2 weeks or so, okay?
All right, thank you.
All right.
And I
good
do
luck.
need that information, Your Honor. I'll hold on the chat for that information.
We'll send it to the attorney.
Okay, we'll send it to you, Ms. Rothman.
Thank you.
All right,
Thank you, Your
y'all-
Honor.
Y'all have a good day. Good to see you as always.
Thank you, you too.
Okay, let's see. At this point, court will be in recess for the attorneys to speak with one another. Whenever you all are ready, please let me know. Okay. Court's in recess. Mr. DeCosta, are you with me?
Yes, sir, Your Honor, I am.
Would you mind sending me the calendars for tomorrow, please?
Just a moment, sir. Yes, sir.
Okay, thank you. I appreciate it.
I believe I've sent them over, Your Honor. Did you receive them?
Give me just a moment. Yes, I did. Thank you, Mr. DeCosta. I appreciate it.
You're welcome.
Okay,
For Mr. Ouellette's case, I just want to let you know, I got in touch with Mr. Roulette. He's currently at work. He's talked to his manager. He's going to be here about 10:10.
Okay, very good. Thank you. I'm glad that we could get that accomplished. So,
Thank you.
okay. Ms. Rothman, are you with me?
Yes, Your Honor. I just, pardon me, I just received the information from Mr. Randolph.
Okay, great. I just wanted to make sure that you did. You have a good day.
Thank you. Thank you.
Okay,
Yes, Judge. With respect to position number 3, Mr. Carlos Hoyos. Defense counsel and I have had a chance to speak. I believe some of the discovery requests have been complied with. The supplemental report from Officer Pacheco, I believe he has. There is a phone interview with who we believe to be the defendant that was provided. But as defense counsel stated, there is apparently some issues with hearing that audio. And so I want to see whether or not there is a more enhanced recording that can be provided with the defendant's statements. And then also too, I need to look into getting him the body cam of the assisting officers that came out to the scene. I'm going to do that obviously this week once I get back to my office. But then I think what we discussed is that potentially based on that, those things being provided, he may amend his motion a little bit based on what he gleans from that. And so we would be asking to put this on some type of a status calendar where it could stay with me. So that we can then, in the meantime, maybe potentially work out a resolution, but then also get him those things that he may need in order to amend his motion. To be able to have that hearing if we need it.
okay.
That's correct, Judge. So we would just look for a time when, ideally, until we know exactly what we're doing, we could, both my client and I could appear virtually as well. So that, and then Ms. Waldrop and I will see if we can't just work this out as well.
Okay, so you're with me with motions, so can we just put it on another motions calendar for some
Yeah,
time?
Judge, if it
And
would
if
just
it's
be
a
far
plea-
enough out.
Right, and what would we anticipate would be far enough out?
I mean, I would say maybe the month of May. Would that work?
Well, on my calendar right now.
Okay.
And I'm not sure, I'm not sure, I can't give you a date certain, but at least I can give you a month.
May would be a pretty good month for me right now, so.
Okay, so we'll see if we can reschedule it for sometime in May. If it continues to be a motion, we'll hear the motions on that date. That should give everybody enough time. If it's a plea, we'll take the plea on that day.
Okay, and I take it, so Ms. Waldrop and Mr. Randolph are my contact people for both the court and for the solicitor's office?
Yes.
Yes.
Okay, very good.
All right.
Okay.
Thank you all for working it out.
Thank you.
Copy of the motion that the defense filed in the
Yes.
file now?
Well, I have the physical copy. I
That
don't
was
think
sent
it's,
to someone else?
yes, but I don't think it's an Odyssey, but obviously we're having issues with Odyssey.
Right,
so.
okay.
Can the defense file a copy of his motion with the court before he leaves?
I have a copy.
Okay, thank you.
Okay.
Okay.
All right,
All right.
thank you. I
Take care.
appreciate it.
Okay, bye-bye.
And Mr. Hoyes, you have a good day also, sir. Thank you. What's the next?
Yes,
announcement?
Your Honor, for position 4, State versus Kelly, we were unable to reach any resolution in this case. Mr. Kelly does have some one prior as well as a subsequent DUI. And so the state will still be asking for a reset in this case. And I would remind Your Honor, this is the first time this has come up on motions calendar.
Okay. Yes,
Thank you, Your Honor. So the court heard me recite to OC.
I'm sorry. Let me, just for the record, court calls the case of State versus John Kelly, case 21 CR 0070668E. It is a 2/21/24 motions calendar. Yes.
Thank you, Your Honor. Casey Cleaver here for Mr. Kelly, who's present. I'm objecting to the state's request for a continuance. And just now that we're on the record, I'll just go ahead and cite to that statute I mentioned earlier. That's OCGA 17-825, titled Absence of Witness as Grounds for Granting Continuance. And that statute reads that in all applications for continuances upon the ground of the absence of a witness, it shall be shown to the court that the witness is absent, that the witness has been subpoenaed, that he does not reside more than 100 miles from the place of trial by the nearest practical route, that his testimony is material, that the witness is not absent by the permission, directly or indirectly, of the applicant, that the applicant expects he will be able to procure the testimony of the witness at the next term of court, that the application is not made for the purpose of delay, but to enable the applicant to procure the testimony of the absent witness, and the application must state the facts expected to be proved by the absent witness. And Your Honor does have discretion. However, under OCGA 24-13-26, enforcement of subpoenas, continuances, secondary evidence of books, papers, or documents, under subsection B, in relevant part, it says that the court may also, in appropriate proceedings, grant continuances of the proceeding. Where subpoenas were issued in blank, no continuance shall be granted because of failure to respond thereto when the party obtaining such subpoenas fails to present to the clerk the name and address of the witnesses so subpoenaed at least 6 hours before appearance is required. So first we have the law, which is very clear, mandatory language. The state shall make a showing to Your Honor of all those things stated in the statute. One of them is that the witness had been subpoenaed, and the state clearly acknowledges that this witness never received a subpoena. They didn't make any showings under that statute. And the second statute, the court has discretion to grant continuances, except no continuance shall be granted because of a failure to respond thereto. And the state has failed to make their showing there. So number one, just the law. The law clearly states that the state shall not be granted a continuance in this situation. And then two, just fundamental fairness. You know, we've been prepared on this case. We've responded to the court's notices. We've appeared at status hearings and scheduling this case for motions. We're here at motions. We're ready. Mr. Kelly has appeared in person to resolve this issue. And just out of principles of fundamental fairness, I mean, we're here, we're ready. It's not fair that the state should just get a free pass because, oh, well, we had this mix up with the officer. I think Your Honor should hold their feet to the fire. And we shouldn't just give a free pass just because it's the first time on. I mean, this case it's a very old case, and we're trying to move these things along in our ORCA calendar, specially designed to take care of these older cases. And the state they cannot meet their burden under the law. I think it'd be unfair to grant them a continuance because of their issues in subpoenaing the officer. So I respectfully object to their request for continuance. I ask that you deny it and grant our motions.
Mr. Birch, anything further?
Does Your Honor have access to review the, excuse me, I'll stand up, to review the posture of this case in Odyssey Research to see when it has been set down and when it has been heard in court in the past?
I don't, but let me just tell you what I believe that I am going to allow you all to do. I would like for you to place your argument in writing for me, citing whatever you need to cite. I would like for the state to also place their argument in writing for me, citing whatever it is that you would like me to consider. So I'm going to give you both the opportunity to brief the issue so that I can be fully informed. So I guess I say that to say that anything that you want to present to me, I'm going to allow you the time to present it to me before I make a ruling on it.
Okay.
Okay?
Can we respond briefly?
Of course, yeah. But I just wanted to let you know that I was already going to allow you all to brief the issue. But go ahead.
So the case in front of you, Your Honor, was reset from a motion hearing on the 14th of February, but we didn't have one because Mr. Cleaver filed a leave of absence. That was also the situation in November of this year. And I can count all the way back to the first leave of absence filed in March of 2022. Motions, discovery, and no actual hearing on this case whatsoever until it was transferred down to this unit. This morning, when asked about the defendant's third DUI that occurred in May of this year, we eventually got confirmation by calling the North Carolina agency and confirmed that that was a guilty plea. There's not been a meaningful or honest conversation about that criminal history until now. As you know, there's a cyber situation, so we might have the ability to read certain things now. But when preparing for this case, the information in Odyssey shows that our officer is now in a different county, but that wasn't available to us. So the subpoena was sent to his Alpharetta PD, who informed us he's no longer there and they don't have his info. We were able to get that info and speak with him yesterday. That is the reason why we're requesting a continuance. He is available. This case is ripe, and we have attempted to negotiate. There has literally never been a hearing in this case. And it has not been because the state has requested resets. So there is no attempt to delay on the part of the state. There is no actual delay that we are creating by asking for a reset from this calendar to the next motions calendar. There wasn't our conversation about resolution of this case. And this would be the third DUI for this gentleman. Any delay in this case moving forward since the arrest of this gentleman in 2021 can be reviewed in the system and seen with every leave of absence for conflict filed and no evidentiary or substantial hearings ever being held.
So just in a nutshell, the reason that you all are having difficulty is basically because of the situation that we're having with our systems at the time.
Correct. So we were able to start to access just basic information that you can read in Odyssey, maybe 2-3 weeks into this. That information, when you look up this officer, has notes that says he's now in this county and this is how you get in touch with him. We didn't have that when a subpoena was sent to Alpharetta. So Alpharetta had to remind us that that's something in our system that we would know and would have known when we subpoenaed him if we'd had access to our information. But right now we're using e-research to go around to try to document our cases and identify what we can move forward with, what we're missing evidence on, and how to make sure we get our officers here. So it was just an information issue related to the cyber attack. We've spoken to Officer Thaxton, who's now in Forsyth County. And so, you know, this case is a triable case.
Just very briefly, Your Honor. And I think what might be best just to resolve the issue of the state's motion for continuance procedurally, if they can file a motion for continuance and state the basis on which they're seeking the motion, the issues they've been having in issuing the subpoena, and then, you know, any law they want to cite, and then allow some time for me to respond to their motion for a continuance. I think that's probably mechanically the best way to go about the written briefs. I will also add that, you know, Madam Solicitor mentioned something about honest negotiations, and that implying or expressly stating that I've been dishonest. Today, I had a very frank conversation with Mr. Birch, and where I actually had him call his law office up in North Carolina to just, it's the first time I had heard about any type of case in North Carolina, and they confirmed for me the details, and I even disclosed and shared to Mr. Birch what my findings were. So I don't appreciate the characterization that I've been in any way dishonest. I'm fulfilling my duties in candor I'm fulfilling my duties of candor to the court, to my colleagues across the way, and this is the first I've learned of it. So when Your Honor said, let's negotiate the case, that's exactly what I did. No way being dishonest. So lastly, and you know, we'll address all the legal issues in the brief, but that's my thinking about the motions in the brief. They file theirs, then I have some time to respond. I think that's probably the best way to go about it.
And I would, Your Honor, argue that there's no need for a brief. Mr. Cleaver does a lot of civil litigation and he loves to file motions. That's why we're here today. This is very basic. We're asking for a continuance. We have not asked for a continuance. It's Mr. Cleaver who's filed leave after leave after leave in this court since 2022. We're ready to move forward. We offered a less safe in this case, and Mr. Cleaver and his client want a reckless for the third DUI. And that's not something we're willing to do. So this is going to be a trial.
Yeah, and their offer, you know, I understand their offer and their position on it. That's fine. But also about the leave, I mean, those are filed according to the rules, 30 days in advance, up to 30 days. If anyone has an objection to it, they can do it at the time. And there's never been any objection to my leaves, and I'm permitted to take leaves. They just happen to, when I file them, then we happen to get scheduled for motions dates. So, you know, and the issue is not whether what the delay of the case is attributable to. It's the fact of states asking for continuance. Here's what the law is in the circumstance and whether they're permitted to get the continuance. So
The law you referenced specifically states that this court needs to hear from the state that our request for a continuance is not for the purpose of creating an undue delay.
correct. It's this applicant, the person applying for a continuance has to make a showing. That's the state.
Yeah, that's what I
No.
just did.
So that's nothing further from you.
Okay, so let me start by saying, with the whole on, I didn't take it that she was disparaging you, Mr. Cleaver. I just think that, her word choice was, that they've been honest, not that you've been dishonest. So the court didn't take it that way. You've appeared before me before. You both have. I don't, you know, I respect you both, and I didn't take it that she was trying to disparage you. You know, we have a special circumstance right now, and because of what's going on in Fulton County, I'm given a lot of leeway because of that. I do appreciate both sides want to move this matter along. That's what I'm here to do. I'm here all next week, okay? If you all can get together on a date, you know, if one of my trials falls through, I have a date that's open already, where I don't have anything scheduled, where I have an ORCA, 2 days actually. So if you all want to come back next week, if that's possible, and move forward with that, with the motion, with very minimum delay, then I'm happy to do that. I'll allow you all to work that out between yourselves as to when you think that you can get that done, and I'm happy to be here, okay? But I agree with the state at this point. My first inclination was that I allow you to brief it based on what you had said, but because of the problems that we're experiencing, I don't want to hold it against anyone. I wouldn't hold it against you if you were in their circumstance, so I'm not going to hold it against them. So what I would ask that you all do is, while you're here today, get together. If you can come up with a date next week, I'm happy to be here. I'm happy to move forward with it. Whatever day is good for you all. If you're not, and you want, you know, we'll just put it on a calendar in the future. But I'm here next week, and I'm happy to get this moved forward, okay?
Thank you, Your Honor, for your flexibility. And just for the record, I understand the court is granting the state's motion for a continuance over a defense objection.
Exactly, yes. And that's specifically because of the reasons that we are having with the system. They are unprecedented. There's something that, you know, that nobody's able to get around. So I don't think it's fair to hold to not allow the continuance because of that, okay?
Thank you, Your Honor. I would just ask that if our next motions hearing, we run into a similar issue with the unavailability of a witness, that the state not be granted a motion for continuance.
Okay, well, I'll hear that.
At that time.
When that comes up.
All right.
They might not have, I mean, this is a particular circumstance, I think, as we all know, so, all right, very good. So before you, I know you have another matter to take up, but before you all leave, you all discuss it and get with me about it if it's doable for next week. If it's not doable, then we'll just put it on a motions calendar as soon as we can get it on there.
Yes, Your
Okay?
Honor.
All right, very good. Thank you.
Excuse me, Your Honor.
Yes.
May I just have the name of both of the solicitors who've been speaking on this case?
Of course, I'm Anna Allen, ANAALLEN for the state.
And James Birch, JAMESBURCH for the state.
Perfect, thank you.
Of course. I've pulled up the Research Georgia site, which we now have access to, that shows the entire posture of this case. The only hearings ever even set for this case were January 2024 and February 2024 motions hearing,
Okay.
ever.
Well, January's a status.
A
Okay.
status and the first motion setting.
All right, so if you all will work that out before the end of the day here. Okay, any other announcements?
Officer Rolfe is here for position 5, and so we can go forward on that one whenever the court's ready.
Okay.
Unless, is Mr. Ouellette here?
Not yet, Your Honor. If the court wants to take up some other matters.
Okay, thank you. As such, the court calls case 21 CR 005732E, State versus William Moore. And if counsel, if you have a copy of any particularized motions, the court would appreciate it. If not, I'll see if I can. Well, we'll make a copy of it.
I can now.
Okay. And counsel, you indicated, first of all, if you would announce yourselves for the record, please.
Is this if I speak over here, Ms. Greenhouse I just want to make sure she can hear me. She can't hear me. I understand it's on, but
I can hear, I just don't see who's speaking, but I can hear who just spoke.
terrific. Okay.
Is that going to cause you difficulty, Ms. Greenhouse, by not?
Not necessarily, as long as I know that it's just one speaker and what the speaker's name is, that would be fine from that location.
Okay.
Okay.
Okay. My name is Larry Cohn. I represent William Moore.
Okay. Thank you.
And James Birch for the state.
Okay, thank you.
And counsel, you were indicating that you were going to streamline.
I can. I've had a chance to speak with Mr. Birch beforehand, and as a result, my understanding from the state is that they're not going to go into any evidence from here or at trial about any breath test samples that were given. So there's no evidence of breath tests. We can stop the case basically right as the officer places him under arrest. There's no need to make any implied consent arguments or anything of that nature. That was the first issue. The second issue that I have, I'm not making a Daubert challenge on any of the field tests, with the exception of if he wants to mention something about vertical gaze nystagmus. I have an issue with that. I can bring that up at the time. I don't think there's any case in the country that allows that, nor any studies in the country that talk about that. HGN is a separate matter. He can testify to that. In addition, what's the other mention? Probable cause, reasonable articulable suspicion for the stop, and probable cause for the arrest at this point would be about it, since we're not going into any chemical testing. And I think that would be sufficient. I missed anything, Mr. Birch?
No, well, just for the record, the state will stipulate that the breath test will be inadmissible for purposes of trial unless the defense opens the door to that issue. And I also understand from opposing counsel that we will not dive into any character evidence as it relates to Officer Rolfe with the Atlanta Police Department.
Right, unless during voir dire, if we pick a jury and someone recognizes the officer, I have no questions to ask the officer about any incidences. that are extraneous to this matter.
Okay.
So one more time, will you state your arguments or your issues?
Okay.
I'm sorry.
Sure. Reasonable suspicion for the stop. Probable cause for the arrest. And I don't think, I've never been in a trial or anywhere in the state where anyone's brought up vertical gaze nystagmus. If you want to talk about HGN, feel free to do that. But the officer did claim or make a statement in his report that he noticed vertical gaze nystagmus, and there's no study, no case anywhere in the United States that talks about that other than police training. So if you have any argument to that.
Right, but we don't have,
When you say we don't have it, are you saying you don't have the GN?
no, well, he says. And I don't have an expert person.
Okay, so do you want to go forward with GN? You need to do it without getting the GN later.
Not really.
Okay, if you don't want to, that's.
Yeah, the state will stipulate that the VGN can be inadmissible for purposes of trial.
Okay, call your first witness.
The state calls Atlanta Police Department Officer Garrett Rolfe. And Officer Rolfe, if you'd stand at the podium right here.
Swear and affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
That your name for the court.
Officer Garrett Rolfe, GARRETTROLFE.
Morning.
Morning.
Good morning, Officer Rolfe. Where are you currently employed?
City of Atlanta Police Department.
Okay, and how long have you been employed there?
This year will be 11 years.
Okay, and were you employed with any other law enforcement agencies before that?
No.
Okay, and are you a post-certified law enforcement officer?
Yes, I am.
And what exactly does that mean?
It means I've completed the basic required training mandated by post and gone through the police academy.
Okay, and do you have any specialized DUI training?
I do.
And would you,
For the purposes of this hearing, I'll stipulate that he's qualified to make arrests. If that works for you, Mr. Birch.
as well as DUI investigations?
Sure.
Okay. Okay, and were you employed by the Atlanta Police Department on May 10th, 2019?
Yes, I was.
And were you on duty around 11:00 PM that evening?
Yes, I was.
Okay, and were you in uniform to include your badge that night?
Yes.
And were you in a marked police vehicle?
Yes, I was.
And did you encounter a person that you later identified as William Moore?
Yes, I did.
Okay, and when you first observed him, what did you see?
I was conducting stationary speed enforcement on I-20 eastbound at Moreland, which is in the city of Atlanta within Fulton County. I observed a vehicle traveling at what I estimated to be 95 miles per hour. Using my LiDAR, I confirmed the speed of the vehicle to be 94 miles per hour and initiated a traffic stop.
Okay, and in what county did this occur?
This is Fulton County.
Okay. And are you trained on speed detection
Yes.
as well as radar usage for speed detection?
Not radar, but LiDAR.
Okay, and would you provide a distinction for the court, please?
Radar uses a different method. LiDAR is a more target specific, using a laser to measure the speed of a vehicle.
Okay. And what was would you once again state the posted speed limit at the incident location?
It's 55 miles per hour.
Okay. And when you pulled over Mr. Moore for speeding that night, did you notice anything about his person?
Well, when I was standing next to the vehicle, I could smell the odor of an alcoholic beverage coming from inside the vehicle.
Okay, and did you notice anything about his face?
I would have to reference my report to see if I notated anything, but not that I recall.
Okay, and did you ask him about the consumption of alcohol that evening?
I did.
Okay, and what was his response?
Initially, when I asked him when he was in the vehicle, he lied and said that he hadn't had anything to drink.
Okay, and then did he change his story?
He did. He later said that he had 2 beers earlier in the evening.
Okay. Did you ask him to perform field sobriety
I did.
tests? And did he agree to that?
He did.
Okay, and which field sobriety test did you perform or did you conduct that evening?
I conducted the horizontal gaze nystagmus test, the walk and turn, and the one leg stand.
Okay, and let's talk about the HGN test. Why don't you tell us about the medical qualification for that?
Well, first we'll check that their pupils are equal in size and that their eyes are equally tracking to make sure that they're not suffering from any medical condition that may make us see something that's not there, or to make sure that they're not suffering from some sort of brain injury or something at the time.
And did you medically qualify Mr. Moore that evening?
I did.
Okay, and so you determined that he was able to perform the HGN.
Yes.
Okay, and what was your test results on the HGN?
I observed 6 out of 6 clues, meaning that I observed lack of smooth pursuit in both eyes, which are 2 clues, distinct and sustained nystagmus at maximum deviation in both eyes, which is another 2 clues, and onset of nystagmus prior to 45 degrees. In this case, it was an immediate angle of onset.
Okay, and did you perform the walk and turn?
I did.
And tell us a little bit about that.
The walk and turn is a battery of tests where the subject is instructed to stand with their feet together, or their feet on an imaginary line, hands done by their side. They're given an instruction to take 9 steps, heel to toe, hands done by their side. At the end, they make a turn with their lead foot planted, make a series of another 9 steps back while counting their steps out loud.
Okay, and what did you score that test on Mr. Moore?
I did. In order to tell you which ones which clues he exhibited on that one, though, I'll have to reference my report.
Okay. Okay, is there anything that would enable you to refresh your recollection?
I have my report on my phone.
Okay, and would you like to look at that report?
Please.
Okay, please take a look.
Okay.
Okay, would you please set aside your police report?
It's quite a few clues, so it's going to be hard to just do it without referencing it every now and then.
Okay, Your Honor, would he be able to reference that during his testimony or?
He needs to go back and refresh his recollection. I'll allow him to do that.
Okay, yeah, if you just read it a couple times, maybe.
Okay.
Yeah. I'm mostly looking for the score here.
Okay, yeah, it was a total of 8 clues is what we're looking for. He exhibited 6 out of 8.
Okay. All right. And then what about the final field sobriety examination?
If I can reference my report real quick.
Sure.
A total of 3 out of 4 clues on the one leg stand.
Okay, so would you sum up the scores of the 3 field sobriety exams?
So 6 out of 6, 6 out of 8, and 3 out of 4.
Okay, now the HGN, the walk and turn, and the one leg stand in order.
Yes.
Okay, okay. All right. And so did you ask Mr. Moore to perform a preliminary breath test that evening?
I did.
And what was his response?
He refused to submit to a preliminary breath test.
Objection, Judge, that would actually, as of now, that's inadmissible under Article 1, Section 1, Paragraph 16. Paragraph under the.
I'll withdraw the question, Your Honor. Yes. Okay. All right, so I'm actually going to bring you back to the walk-in tour, field sobriety. Would you please state for the record exactly which clues you observed?
Okay. So during the instructional phase, we're looking for 2 clues. He exhibited 1. He was unable to maintain his balance. And if I can reference my report for the. for the
Yeah,
other
briefly,
ones.
yes.
During the walking phase, he stepped offline. He stopped while walking. He raised his arms while walking and took an incorrect number of steps.
Okay.
I'm sorry, and he made an improper turn.
All right, and based on your experience, your training, and your observations of the defendant, both as a driver and talking to him on the side of the road that night, and his performance on the field sobriety examinations, did you create an opinion as to whether he was under the influence of alcohol to the extent that he was a less safe driver?
I did.
And what was your opinion?
It was my opinion that he was under the influence to the extent that he was incapable of operating a motor vehicle safely.
Okay, and did you place the defendant under arrest?
I did.
And what specifically did you place him under arrest for?
DUI.
Okay. And I think based upon the stipulations here that we're probably good for the purposes of direct, Your Honor.
Okay. Any cross?
Sure. Officer Rolfe, this case took place on May 10th, 2019.
Yes.
You haven't thought about it since that night. Is that fair to say?
Correct.
Okay. And you just, out of curiosity, you testified really, looks like without any sort of notes from your just phone or police report. Is that right?
Just referencing my police report. Yes.
Okay. And you reviewed that before coming here today. Is that correct?
Yes.
Okay. And you're trained to write down important details. Is that right?
Yes.
And your memory's better then than it is now. Is that true?
Yeah. More recent, more closer to the incident. Yes.
Okay. And back in 2019, you had a body camera. Is that correct?
Yes, I believe so.
And you had a dash camera. Is that correct?
There was a period of time where we were without dash cameras. I don't know if it was during that, but it should have. Yes.
Okay. And when you prepared your police report, did you prepare that after watching your videos?
Typically, I would, unless there was something that I couldn't recall. It depends. I wouldn't know if I referenced my camera when I wrote this report or not.
But this case, there was a video. Is that right?
Yes, there should be.
Okay. And you'd agree with me that the video would be a fair and accurate depiction of what took place that night. Is that right?
Yes.
Even probably better than your memory. Is that correct?
Most likely, yes.
Okay. And if he was not sitting next to me, would you have recognized him on the street?
No.
Okay. And if I just gave you his name, William Moore, would you recognize the name?
No.
Common name, right?
Yes.
Okay. I want to bring your attention back to May 10th, 2019. And aside from your report, do you have any specific recollection of that evening?
No.
Okay. And you couldn't tell us what he was wearing. Is that true?
No, I couldn't.
Okay. And you don't even, without looking at the report, could you tell us what sort of car he was driving?
No.
What sort of car was he driving?
I believe it was an Infiniti. I couldn't tell you the model.
What color was it?
I don't recall.
You indicated that you're running laser at I-20 eastbound at Moreland.
Yes.
Is that correct?
Yes.
Okay. And you'd agree with me that when he pulled over and stopped, you arrested him in DeKalb County. Is that correct?
I don't remember exactly where we stopped, but the violation was observed in Fulton County.
Well, if you're running laser I-20 eastbound at Moreland, you'd agree with me that Moreland splits is the boundary between Fulton and DeKalb. Is that correct?
Yes, but when I say that, that could have been the next reference point. I may have been a little west of it. I would have to look at the video to see exactly where we stopped.
We don't have the video, do we?
I don't have it.
Okay. And so can you truthfully say today, because you were stopped, you had to catch up to his vehicle, is that correct?
Yes.
And he's going 94 miles an hour.
Correct.
While he was driving, you had no idea if he was DUI or not. Is that correct?
Correct.
Can you tell us where you learned everything about this case? Was it in DeKalb or was it in Fulton County?
I observed the violation in Fulton. I would have to reference the video to see exactly where we stopped, but the violations were observed in Fulton.
But you'd agree with me that if you had to come from a dead stop to catch up to somebody going 94 miles an hour and you're close to Moreland, how long would it take for you to get up to 94 miles an hour to have him stop?
It could take a while.
So you don't know exactly where he stopped, do you?
Correct.
Okay.
I just know that the violation was observed in Fulton County.
Okay. Do you recall if it was raining that night?
No.
Do you recall if he had any passengers in his car?
No.
Okay. Do you recall if you had the car towed?
No.
Okay. Do you recall if any of his passengers were able to drive the car away from the scene?
I don't recall if there were any.
Were there any officers with you at the scene?
Not that I recall.
Okay. You're sure of that?
No.
Okay. Was there anything that you asked him to do? And the reason I'm bringing this up is that you mentioned something about an Alka sensor or portable breath test. Is that right?
Yes.
There's no mention of that in your report, is there?
I would have to look.
You can look. And again, I'm not going into this for the purpose of admissibility of the Alka sensor. I'm just under 24-6-611. I'm entitled to cross-examine the officer on his recollection of the events.
I did ask him to submit to a preliminary breath test and he refused.
Okay,
Which would have been with that instrument.
I'm just asking. It's not in the report, is it?
Yes, it's in the report that I asked him to submit to a preliminary breath test.
I'm just looking at the same report, I believe that you are. Where does it say that?
In the second paragraph. Second sentence.
Gotcha. Okay, good. I had missed that. Thank you for bringing it to my recollection. Do you recall his speech that evening?
Unless I notated it in my report, I don't off the top of my head.
And you'd agree with me that slurred speech or thick speech could be a sign of someone who's impaired. Is that true?
Yes, it could be.
Okay. And you didn't notice any of that in this case, did you?
Unless I notated it in my report, I don't recall.
Okay. So is it that you don't recall or that he did not have impaired speech?
If I didn't notate it in my report, without referencing the video, I wouldn't be able to recall.
Okay. So his speech sounded normal to you. Is that correct that evening?
I don't recall either way.
Okay. But there was a body camera that would depict exactly how he sounded. Is that right?
Yes.
And a body camera would depict exactly what he said to you that night. Is that correct?
Yes.
Where was he headed?
I don't know.
Where was he coming from?
From west. It would be all I know.
Okay. But you would typically ask people where they were coming from or where they were going to in a case, wouldn't you?
Not always.
Okay. Would you ask them when he finished his last drink?
Typically, maybe.
Did you do that in this case?
I don't recall.
Okay. He told you he had 2 beers. Is that right?
Well, initially he said that he hadn't had anything to drink at all. And then he said, after refusing to submit to the preliminary breath test, that he had 2 beers earlier in the evening.
Well, let me ask you that question. The preliminary breath test that you put in your report, is that generally the first thing that you would do, or isn't that the last thing that you would do before arresting somebody?
Well, actually, by policy, we are required to do it before and after field sobriety tests.
Are you certain that you did that in this case?
That I attempted to, yes.
You have a recollection of that, or are you just going by what your policy is?
I'm going off of my report.
Now, your report just says he refused the test. Do you remember if he refused the first time or the second time?
Well, it's written in chronological order. So I asked him to submit to it before any preliminary breath tests, and that was to counter him saying that he hadn't had anything to drink when I could clearly smell the odor of an alcoholic beverage on his breath.
No, based on the odor, you don't know what somebody was drinking. Is that true?
I wouldn't be able to tell specifically what drink.
You wouldn't know how much someone had to drink?
No.
Okay. But from the statement that he had 2 beers, when did he finish his last beer? Do you have any recollection?
He just said earlier in the evening.
You didn't ask him for follow-up, or you don't recall?
I don't recall if I went further into it.
Okay. How long did it take for him to stop after you put your blue lights on?
I don't recall.
You didn't have to chase him down, did you?
No, I don't believe so.
Did he use a signal to stop to pull over?
I don't recall.
Okay. And you asked him for his driver's license, is that correct?
Typically I would. I couldn't say for sure without referencing the body camera footage.
Okay. Do you recall if he handed you his license appropriately?
If he hadn't, I probably would have notated it in my report.
So he didn't fumble through his wallet and hand you a credit card or something. Is that correct?
Not that I recall.
And that would be a sign of impairment, right?
It could be.
Okay, but that didn't happen in this case, did it?
Not that I recall.
Um, did you ever have to ask him to repeat himself?
Oh, I would have to watch the video. I'm not
What you're
sure.
saying is you don't recall.
Not that I recall. No.
So basically, if it's not written in the report, you really just don't recall this case. Is that true?
Without watching the body camera footage, if it's not in the report, then yes, I don't recall.
The first test you gave him was the horizontal gaze nystagmus. Is that right?
Yes,
Okay. And there was no decision to arrest him after that, correct?
correct.
Okay. The entire time that you were with him, and let me back up. You have training in terms of personal observations of people under the influence and through your training as a police officer. You'd agree with me that balance is important. Is that correct? To make a determination if someone's impaired?
Yeah, it's part of the battery of tests, yes.
And at no point, other than, I guess, the field sobriety test, did he sway or appear unsteady on his feet, did he?
Not that I recall.
And when you asked him to get out of his vehicle, he didn't have to grab onto his car for support, correct?
No, not that I recall.
Okay. And when he walked to the back of the car, which is where you would have done field tests on him, was his walk steady or unsteady?
Typically, I would make a passenger side approach, so I wouldn't observe his gait as he was exiting the vehicle, but again, not that I recall.
Okay.
So I think the dash cam would have a better angle of that.
Do you recall him telling you anything about his size, 14 feet?
No, I don't.
Okay. Do you recall what sort of shoes he was wearing for his tests?
No, I don't.
Do you recall the weather that night?
No.
Okay. When you pulled him over, did any other vehicle have to move out of his way of driving?
Not that I recall.
Okay. Was traffic light that night?
I don't recall.
Okay. And when you perform the HGN test after you notice the clues, what do those clues mean to you?
Well, how do you mean?
You said you testified on direct that he got 6 out of 6 clues. What does that mean to you?
Well, two clues on each of the tests is indicative of impairment, and 6 out of 6 clues means that he exhibited all of the clues on the HGN test, indicating that he was impaired based off of just the results of that test.
Okay. Now, with regard to the walk and turn test, was there a line?
No.
Okay. You certain of that?
No, I'm not.
You just don't recall?
I typically, as a practice, never had anybody walk on an actual line. I would have them imagine an imaginary line out in front of them.
Okay. Do you recall?
But I wouldn't put a line down or anything like that.
Do you recall him keeping his arms by his side?
I would have to reference my report to see if he raised his arms during the test.
You just don't recall?
I would have, no, not without referencing.
Okay. If you want to look at your report, you can look at your report.
In my report, I notated that he raised his arms for balance.
How high?
I don't know.
Okay. Did he start too soon?
Can I reference my report?
Sure.
No, I didn't notate that he started too soon.
Did he touch heel toe?
Yes, it appeared he did.
Okay. So that'd be a sign of someone that you're looking for, and he didn't exhibit that clue. Is that correct?
Well, not everybody exhibits every clue on every test, but those are 2 of the clues that he did not exhibit.
Okay. But what I'm asking is that you have no independent recollection of him doing the walk and turn test other than your report. Is that true?
Correct. And of course, the video.
But we're not here to see the video, correct?
I don't know.
Okay. And you'd agree with me that a video would be incredibly not just important to see exactly what transpired, but would probably dictate exactly what took place. Is that true?
Yes.
Okay. On the one leg stand, you indicated 3 out of 4 clues. Is that correct?
Correct.
Okay. After he did the walk and turn test, you had not made your decision to arrest him. Is that true?
Correct.
Okay. After the one leg stand test, had you made your decision to arrest him?
Yes.
Okay. And after that, you placed him under arrest. You recall any conversation with him on the way to the jail?
Not that I recall.
He was polite with you the entire time?
Not that I recall, but if he wasn't, or if he was uncooperative in any way, I would have notated it.
Would you agree with me that red or bloodshot eyes could be a sign of impairment?
Yes, it could be.
Okay. Did you notice any red or bloodshot eyes in this case?
Not that I recall.
Okay. What about glossy eyes? Aren't those a sign of impairment as well?
They can be.
Did you notice that in this case?
Not that I recall.
Okay. Other than the standardized field sobriety tests that you gave him, would you agree with me that there's no manifestations of impairment in your report?
Aside from the
Other than
clues on the
field
standardized
tests.
field sobriety test,
Yes.
other than the odor of an alcoholic beverage, no.
And that odor, since he was over the age of 21, driving with an odor of alcohol is not illegal. Is that correct?
Correct.
So my question again is that other than the standardized field sobriety test, there's no manifestations of impairment in the report?
No.
Okay. And odor of alcohol is not an indicator of impairment. It's just an indicator that maybe someone's had something to drink. True?
Correct.
You'd agree with me that there's some people that you've investigated or through your training and life experience that just have better balance than other people. Is that true?
Yes.
Regardless of whether they've had anything to drink?
Yes.
Okay. And just going back to one other question, depending upon where he stopped, this is not a case that took place in downtown Atlanta or somewhere off of I-20 West. You don't know whether you physically placed him in custody in DeKalb or Fulton County, do you?
Correct.
Nothing further.
Redirect.
No, Your Honor.
Okay. Thank you, officer.
Thank you.
Appreciate it. You call your next witness?
Nothing further from the state.
Further counsel?
No, Judge, nothing further from me.
Argument?
I will stipulate to the evidence that's been heard by the case, or heard testified to by the arresting officer in this case. I just will leave my arguments for a jury in this case.
I don't know. Do I need to argue then at this point? I mean,
Not unless you want to.
It's up to you, Mr. Birch. If there's anything you need specific for me to hear, I've heard the evidence as presented.
I mean, from what I understand, defense is stipulating that reasonable articulable suspicion was present as well as probable cause for the DUI arrest.
I'll stipulate to the facts testified to by the officer and the court can render its verdict. How about that?
Right.
Does that make sense? I can't.
Sure. Right. Okay, so as to the reasonable articulable suspicion, the Georgia Court of Appeals tells us in Steinberg versus State, 286 Georgia App 417, the stop of a vehicle is authorized merely when officer observes a traffic offense. And so Officer Rolfe has testified today that he observed a speeding offense, specifically 94 and a 55, and therefore the state has met its burden as to reasonable articulable suspicion. And as for probable cause, the Georgia Court of Appeals tells us in Semeso versus State, 288 Georgia App 291, or excuse me, that's the wrong one. Excuse me, that was the wrong citation, Your Honor. Hughes versus State, 296 Georgia 744, which is the Supreme Court of Georgia. The standard is whether a reasonable officer could, from the totality of the facts and circumstances, conclude the possibility of DUI and driving at the time of the incident. Probable cause is established even when reasonable officers could draw mixed conclusions. And so in this case, Your Honor, Officer Rolfe testified that he performed the full battery of field sobriety examinations, that he was trained to perform those, and that based upon the way he scored each of these field sobriety examinations, that he determined that Mr. Moore was less safe to drive based upon his impairment. And that's the state has met its burden for probable cause for DUI arrest. And so I'll reserve any further argument for a jury trial.
Okay. I'll issue a written ruling Anything further on this matter this morning?
When will this come up for a trial calendar?
We do not have specified trial calendars as of yet, but I will be placing it on my next available trial calendar.
Ballpark, summer, spring?
Summer, spring. It will be as soon as possible, hopefully May, June.
Okay. I just,
Okay.
yeah, plan around that. Okay.
Okay.
Sounds good. Thank you.
And once you get the trial calendar, you know, if you have some type of issue, we'll certainly work around it. Okay?
Yep.
All right. Can your officer be dismissed?
Yes.
Thank you. We appreciate it.
Thank you.
Good to see you, sir.
Thank you.
Good luck to you. We ready for the next matter?
Yes, Your Honor.
And Your Honor, before we get started with Mr. Roulette's case, I had a chance to look at my calendar for potential availability for Mr. Kelly's case. It doesn't look like next week I'm gonna have much availability to come back before Your Honor for a motions hearing. So with that announcement, would it be okay if I were to release Mr. Kelly for today? And then I can get notice from Your Honor regarding his subsequent motions hearing?
Okay, we'll just place it on the next available motions calendar. So yes, he's free to go.
Okay, thank
All
you.
right.
Your Honor, if I may request a brief 3-minute.
Court, you want to recess? So you can
Please.
talk? Okay, court be in recess until council comes back.
You have to sleep.
Okay. Okay, let's see, the court calls a case of State versus Thomas Evan Roulette, case 20 CR 005944F. On the 9 o'clock motions calendar, counsel, if you'll announce yourselves for the court reporter, please.
Yes, Your Honor. Casey Cleaver for Mr. Wallet, and that's CASEY CLEAVER.
James Birch for the state, JAMESBURCH.
Okay, thank you. Have you all narrowed the issues down for determination?
Yes, Your Honor.
Okay, and what are those?
So this case is actually, there's two different motions on for today. You've got my motion to suppress, and then there's one motion in limine issue that Mr. Birch and I had discussed, and then the state also has their previously filed 404B 417 motions. I'll go ahead and start with my motions, and then the state can address those.
Well, the state will be withdrawing the 404 and 417 motions.
I would just ask that they file a motion to withdraw motions. Something in writing.
Okay, so if you'll put that in writing, Mr. Birch, at some point,
And then when the court's ready, I can articulate those narrowed issues.
okay, thank you. Go ahead.
So the first issue for the court's consideration is whether there was reasonable articulable suspicion to justify law enforcement's continued detention of Mr. Wallet. Second, whether law enforcement was pursuing the investigation expeditiously and diligently, and thereby creating an unlawfully prolonged detention. Third, whether the horizontal gaze nystagmus test was done in substantial compliance under the Towsley case. And for Madam Court Reporter, that's TOUSLEY. Fourth, where it's our position that Mr. Wallet was making statements while in custody in response to police questioning without the benefit of any Miranda warnings. Fifth, whether there was sufficient evidence to justify a probable cause determination to arrest Mr. Wallet for driving under the influence less safe. Sixth, we're seeking to have this court find that the field sobriety tests are inadmissible under 702 and Daubert. And I understand the state is going to articulate to the court they don't have any expert witnesses for today's hearing. And I understand the court can either hear that at a pretrial motion, the court can hear it right before trial or even during trial. I'll defer to Your Honor regarding when that's conducted. But just letting you know that's what Mr. Birch and I had discussed. And then lastly, this is stipulated to by Mr. Birch and I previously, is that we would be seeking suppression of the refusal of any request for a chemical test of Mr. Wallet's breath under the implied consent warning pursuant to the Elliott case, and similarly, any refusal to submit to a portable breath test under the Bradbury case. And Mr. Birch and I have discussed that, and he would agree that that would not be admissible at trial unless we were to open the door to such evidence.
So stipulated.
Okay,
Those would be the issues.
okay, thank you, counsel. Anything before you call your first witness, Mr. Birch?
Well, as far as the issue of the 702 for HGN, the state has filed a motion back in September of 2023. I have it available here. Asking Your Honor to take notice of, to take judicial notice of HGN reliability. And there are multiple exhibits pursuant to this motion of court orders as laid out by multiple judges, both inside this building in Fulton County, as well as other judges around the state of Georgia and other state courts. And so, you know, the state does not feel as though a 702 argument for the purpose of HGN reliability and DUI investigations is necessary at this time.
And I am in receipt of that filing by the state back when Ms. Reiser was handling the case. She had provided that to me. And I just don't think this is the type of thing that we can really take judicial notice of because it is so debated. I would ask the court to be, receptive to my arguments on it. I think I might bring up some novel things maybe the court hasn't heard about 702 and Daubert relating to HGN and field sobriety that I don't even know if that Your Honor has heard those arguments before, but I've got some really interesting things that I think the court would be inclined to hear about it. But usually judicial notice is the type of thing where we all readily acknowledge if the state asks, Your Honor, we ask you to take judicial notice that the sky is blue. Okay, yeah, we can do that. Or something that's very common. I think this is up for debate in the scientific community, and I've got some really interesting literature that I'd like to share with Your Honor on the subject during one of those types of hearings. So I just don't think it's so plainly within the scope of judicial notice.
Okay. So that's something that, if necessary, I don't know what's going to happen, but it's something that we can take up before trial.
Yeah, if Your Honor wants to hold a different pretrial hearing just for that, or if Your Honor wants to hear it right before trial or even during trial, Your Honor has discretion on when you can handle that technical motion and limit.
Okay, I think that I will handle that right before trial in that case. Okay. So as far as today goes, anything more than what's been articulated? I just want to make sure I have.
That's it for me for today.
Okay, Mr. Birch.
Ready to proceed, Your Honor.
Okay, call your first witness.
Yeah, the state would call Forsyth County, or excuse me, Hall County Sheriff's Deputy Brian Postma.
Yes, ma'am. My name is Brian Postma, Brian, last name Postma.
Good morning.
Morning, sir.
Let me call you Deputy Postma or Officer.
Anything goes.
Okay, sure. Officer, where do you work right now?
I'm currently employed with the Hall County Sheriff's Office.
Okay, and how long have you been working there?
A little over a year with the Hall County.
Okay, and where did you work before that?
I've been previously employed with Lumpkin County twice and the city of Alpharetta.
Okay, and in total, how many years do you have in law enforcement?
I began my career in 2013.
Okay.
So a little over 11 years.
All right, and are you post certified?
I am.
Okay, and have you received any specialized DUI training?
I have.
And would you tell the court exactly what you have?
I have gone through standardized field sobriety and ARIDE.
Okay, and what is ARIDE?
It's advanced roadside, basically drug impairment.
Okay, and when did you complete their SFST and your ARIDE training?
ARIDE was I believe 2017, December of 2017. SFST was early in my career. I don't believe I remember the exact date.
Okay.
It was when I was with Lumpkin County the first time.
Okay.
Before Alpharetta.
And so would you agree that both of those were done before this incident in this case?
Correct.
Okay. All right. And as a part of your standardized field sobriety testing, are you trained on the horizontal gaze and nystagmus test?
I am.
Okay. And were you employed by City of Alpharetta Police Department on February 25, 2020?
Yes.
Okay. And at around 11 p.m. that evening, were you on duty?
I was.
Okay. And were you in your uniform to include your badge?
Yes.
And were you in a marked police vehicle?
Yes.
Okay. And did you come into, did you encounter a person that you later identified as Thomas Ouellette?
Yes.
Okay. And how were you called to this traffic stop?
I was requested to the traffic stop by another officer, Officer Colello. He had conducted a traffic stop on that vehicle, suspected an impaired driver, requested my assistance with that investigation.
Okay. And did Officer Colello tell you the reason why he stopped the vehicle?
I'm going to object to hearsay, lack of personal knowledge, confrontation.
Yeah. And Your Honor, this would fall under the collective knowledge doctrine as outlined in State versus Perryman, 248 Georgia App 446. Reasonable suspicion for a traffic stop may exist based on collective knowledge of police when there's reliable communication between officers and that officer is acting on that information.
If I could just respond briefly.
Of course.
For collective knowledge doctrine to apply, what we're looking at is if, let's just say, Deputy Postma was the one who conducted the stop, whether Deputy Postma had information from another officer that they could rely on in conducting the stop. So it's actually the inverse here. We would need to know that Deputy Postma had communicated certain things to Officer Colello in order to have Officer Colello have some information that that officer could rely on in making the stop. I think the state's got it just backwards on collective knowledge here.
The state would disagree with that, Your Honor.
What's the question again?
The question is whether we can rely on another officer's.
No. What's the question to the officer?
Did Officer Colello communicate with Officer Postma as to why Mr. Wallet was stopped, why a traffic stop was conducted that evening?
For the purposes of this hearing, I'm going to allow it.
Okay. So same question again. Would you like me to repeat the question?
I believe it was on why the traffic stop was made.
Yes.
Yes, sir. Officer Colello informed me that the stop was conducted on a obedience required to traffic control device. He observed the offender's vehicle cross into the intersection under a red light, past the large white bulk line.
Okay. And why did Officer Colello call you to the scene?
Objection calls for speculation, personal knowledge.
Is it common for you to be called to assist in DUI investigations?
From time to time, yes.
And why would that be?
Number of reasons, lack of training on impaired driving. Some officers just don't like working DUIs. And so I'll assist in that. I'm not sure his reasoning why he called me, other than he believed he had a impaired driver and requested me to take over the investigation.
Okay. Okay. And when you encountered Mr. Wallet, did he make any manifestations of impairment? Did you observe any manifestations of impairment?
I'd have to refer to my report, but I believe I noted I observed a red and watery eyes and an odor of alcoholic beverage coming from his person.
Okay. And did you know where Mr. Wallet was coming from that evening?
I was briefed by Deputy or Officer Collette that he was he had left work at Jekyll Brewery.
Okay. Jekyll Brewery.
Yes.
Okay. And did Mr. Wallet admit to drinking any alcohol on the night of the incident?
He did.
Okay. And did he state how much?
Approximately 2, I believe. I'd have to refer to my report again, but I believe it was 2 beers, maybe possibly 2 12-ounce beers.
Okay. All right. And did you ask him to perform standardized field sobriety testing that night?
I did.
Okay. And did he comply?
Yes, he agreed.
Okay. And did you medically qualify him for the field sobriety examinations?
I did.
Okay. And would you please explain to the court exactly how you would medically qualify someone for field sobriety examinations?
Starting off with asking if there were contacts or glasses, any kind of prescription medications that were taken, any medical conditions that would prevent them from not being able to perform any of the battery tests.
Okay. All right. And then what was the first standardized field sobriety examination that you conducted?
The horizontal gaze nystagmus.
Okay. And how would you perform that?
I'd have them focus on a stimulus. In this case, I was the tip of my finger, and then make a series of passes with their eyes and their eyes only, from side to side horizontally, to check for nystagmus.
And how many were you able to score the HGN examination?
Yes.
And how many clues did you observe?
I observed, noted in my report, 6 out of 6.
Okay. And did you perform another field sobriety examination that night?
Yes, after that, I performed the walk and turn battery.
All right, and would you explain that to the court?
With the walk and turn examination, the subject is placed on an imaginary line, asked to walk heel to toe 9 steps down that line with their hands down by their side, leaving their lead foot in place, taking a series of small steps, turning around and returning back down that same line, 9 heel to toe steps with their hands down by their side, while counting out loud.
Okay. And were you able to score the walk and turn test that night?
I did.
And do you know how many clues you observed?
I'd have to refer to my report, if you don't mind, just so I can just get the number off of it.
Okay. May I show you him his report, Your Honor?
Yes.
Thank you. I believe it was 3 out of 8.
Okay. And did you do another standardized field sobriety test after that?
Yes,
And which one was that?
the one leg stand.
Okay, and would you please briefly describe that?
The subject would be asked to stand on one leg of their choosing, lifting the other approximately 6 inches off the ground, their leg straight, toe pointed out, while focusing on their elevated foot. They would be asked to count by 1,000s for a period of, I believe, 30 seconds.
Okay. And were you able to score this test?
Yes,
And how many clues did you observe?
I may refer
Briefly.
observed 2 out of the 4.
Okay. And how many DUI investigations have you conducted throughout your career, officer?
I don't have a actual number, but I've done several over the course of my career. I mean, several, probably a couple hundred.
Several hundred, a couple hundred. How many of those would you say you had completed prior to the date of this incident?
Again, I don't have a number, but I've done a fair share. I worked in Lumpkin County, which was a college town with a large military base, so there was a lot of drinking. So I've encountered a lot of impaired investigations.
Okay. And based upon your experience, your training, the observations that you observed that night, as well as the communication you had with Officer Colello, did you form an opinion as to whether or not Mr. Wallet was under the influence of alcohol to the extent that he was a less safe driver?
Yes, based after the collective of my entirety of the investigation, I did.
Okay, and what was that opinion?
That he was a less safe driver to be operating a vehicle.
Okay, and did you place the defendant under arrest for DUI?
I did.
Okay. Were you wearing a body worn camera that night?
I was.
Okay, and was it operating that evening?
Yes,
It was in good working order?
it was.
Okay, and have you had the opportunity to review that footage?
I did.
Okay, may I approach the witness, Your Honor?
Yes.
And I've handed you what's been previously marked as State's Exhibit number 1. Do you recognize this?
Yes, it's labeled as State Versatile Post-Mobile Body Worn Camera, or PWC.
Okay, and is this the recording of your interaction with Mr. Wallet on the night of the incident?
To my recollection, yes. That's what I
Okay.
reviewed,
And has this been materially altered in any way?
not to my knowledge.
Okay. At this time, Your Honor, the state would move to exhibit, would move to tender State's Exhibit 1 into evidence.
Any objection?
No objection, Your Honor. I just don't know if, which screen would be broadcasted on?
Well, I believe it would hit that one right on your table, this computer screen. It would be this one, and several up here as well.
No objection. I just wasn't sure if the officer had been looking at it while he was laying a foundation, but no objection for the purpose of this hearing.
Okay, I admit it without objection.
Okay, and may I publish this video, Your Honor?
Yes.
If you'll bear with me, I've got to
Okay.
connect to the Zoom. I have a copy, yeah. And you can probably take a seat for a minute.
Okay.
Yeah. Mr. DaCosta, are you with us?
Yes, I am.
Okay, if you'd please make me a host.
Just a second. You're good to go.
Thank you.
I was over on Lakeview and Haynes sitting at the light, and he blew through the intersection, just came to a dead stop. He said he was on his phone with his buddy. He works at Jekyll Brewing, said he had a couple of drinks after he got off tonight. They closed about, 10:30? So within the past hour, he's had a couple of drinks. I just want to make sure he's.
Can you turn that up?
Because I also blue lighted him over on Haynes and 400, and he just kept on going.
I believe it's the house speakers that need to be turned up. Is there a control back there? Mr. Randolph, are you familiar?
Be on TV. Should it be on TV? Did a remote control.
Like he didn't know where to pull off or nothing. So.
Okay. All right. What's your name, man? Thomas? Hey, man, I'm Officer Postman. You be willing to do some field sobriety testing?
Yes, sir.
Okay. Do you mind turning your front lights off? Thomas, you said?
Mm-hmm.
All right. What all did you have to drink?
I had 2 beers at Jekyll.
2 beers?
Yes, sir.
How big were they?
12.
Just a normal 12 ounce?
Normal beer, yeah.
Okay. Well, all right. How long?
About an hour ago.
An hour?
Yes, sir.
Okay. All right. You all right?
Yeah. Yes.
Okay. You what? Okay. Do you wear contacts or glasses?
Yes, sir.
No? Do you take any kind of prescription medication?
Yes, sir.
Nothing at all?
Yes, sir.
Okay. Do you have any issues with your knees, hips, backs, or ankles? Anything with your joints
Yes,
that prevent you from walking and turning and standing on one leg? No, none at all? Okay. Are you comfortable with what you're wearing right now?
Yes.
Okay. All right. We're going to come over in front of my car. Actually, we just kill all your front lights. And just give me 1 second. We turn something on real quick. I'll be right back, okay? 28 out on field. All right, man. So what I'm gonna do is just do a couple like a quick eye test. We do a couple passes back and forth, a walk and turn, and a one leg stand. Okay, and we'll go from there. Does that sound good? Okay. What I would need you to do is feet together, hands down by your side, just how I am. All right, exactly like that. All right. What hand do you write with? Right. All right. Do you mind holding your hat with your right hand, just down to your side? Cool. Thank you, man. All right. Can you see the tip of my finger right here? All right. What I want you to do is follow your eyes in your eyes only. The tip of my finger. Do not move your head. Do you understand? Yes, sir. Okay. All right. You're starting to move your head just a little bit. Just keep it still facing me. If you need to blink, you go ahead and blink. Okay. Try to keep your head straight with me. All right. I'm gonna do the same thing. I'm gonna go up, down, then up, back up with it. Okay. Keep following my finger. Keep your head still though. Okay. I'll start that over. Look, straight, just normal. All right. Follow the finger. All right. Try not to move your head. Okay. Just keep your head still. Just your eyes. All right, man. All right. You can put your hat back on if you want. Okay. So. Yeah, this is pretty flat. All right. So, can you just stand right where you're at? That's fine. Can you imagine a straight line on the ground going from your left foot all the way out to kind of out towards your car a little bit? Can you just, huh? Left foot first. Just wait. Just listen to what I'm saying. I'm not going to tell you. Don't walk yet. I'll tell you when to walk. But can you imagine a straight line on the ground? All right. With that straight line in mind. Yep. All right, with that straight line in mind. Left foot on the line. Right foot in front of left foot. Heel touching toe. Just like this. And then hands down by your side. Go ahead and get in that position now. Left foot on the line, right foot in front of left foot, heel touching toe. Heel of your right foot touching the toe of your left foot. Okay. Heel of your right foot touching the heel, just like that. A little bit more. Okay. You want to get that paper off your foot? You can just toss it. Okay. Then hands down by your side. Stay in that position until I tell you otherwise. Until I tell you to begin. Do you understand? All right. When I tell you to begin, take a series of 9 heel-to-toe steps, counting out loud, down this line in a manner like so. 1, 2, 3, so forth and so on until you reach 9 steps. When you reach your 9th step, leave your lead foot in place. Take a series of small steps, turning back around, and then returning back down that line, 9 heel-to-toe steps, counting out loud. 1, 2, 3. I took 3 steps for demonstration. You are going to take 9. Okay? What I want you to keep in mind is eyes on the line. Count each step out loud. Hands up. It's fine. Go ahead and get back in. Hands down by your side. Once you start walking, do not stop until you finish. Do you understand? Yes, sir. All right. Whenever you're ready, you can begin.
I'm just letting you know,
do you want to take your shoe off and do it barefoot? You're welcome to do.
It's fine. I'll do
You have that option. If you don't want to, if you think that's going to be a distraction for you, take your shoe off, man. Take your shoes off. You can put them back on when we're done. Or unless you have other shoes you want to put on, but they're good right there. Just go ahead and do it barefoot if you want. Do you remember the instructions?
Yes, sir.
Left foot on the line, right foot in front of left foot, heel touch and toe. Nine heel to toe steps down. Leave foot in place. Turn back around. Nine heel toe steps back, counting out loud.
Sir.
All right, whenever you're ready, you can begin.
1, 2, 3, 4, 5, 6, 7, 8, 9.
Okay.
1, 2, 3, 4, 5, 6,
Okay.
7, 8.
All right, cool, man. All right, so this next one's going to be a one-leg stand. You can either do it barefoot or in your socks, or you can put your shoes back on. Either way, it's up to you, okay? If you want to take a step away from the bumper, just in case you happen to lose your balance, I don't want you to hit your head.
Okay.
All right. This one, you can take either foot you're choosing, left or right. That's your choice, okay? You can take your one foot, lift it up 6 inches up, not yet, 6 inches off the ground, toe pointed out, leg straight, or leg straight, toe pointed out, okay? You're going to look at your elevated foot, count out loud, 1001, 1002, 1003, so forth, so on, until I tell you to stop. Do you understand?
Yes,
All right. Keep your eyes on the elevated foot, count out loud, hands down by your side. All right, I'll tell you when to begin, okay? Oh, sorry, I didn't mean to shine that in your face. All right, you can begin.
1001, 1002, 1003, 1004, 1005, 2006.
Keep going.
So 1001, 1002, 1003, 1004, 2005, 2006, 2007, 2008, 2009, 2010, 2011, 2012, 2013, 2000. 1001,
Okay,
1002.
you're good, man. You want to put your shoes back on? Go ahead and put your shoes back on. Were you back in the back doing dishes? Or we're mopping or something with their cleaning the floors?
You can look at my shoes. They're
Yeah.
wet, my feet are wet.
Or they come through with that bucket of water every once in a while? Is that what they did? All right, you all good on your shoes? All right, man. What I need you to do, or I would like you to do, is take a deep breath and just blow through the tube, not around it. It's just positive, negative reading for alcohol. That's all I use it for. Not a number. It's just yes or no for alcohol. Present on your breath. Just something I use to confirm.
I've been through this before.
Okay.
If
It's just another tool I use in part of my investigation. Okay, I'm just being honest with you. It's voluntary. All I use it for. They will give me a number, but I only use it for anything over 0.00000 is a positive for alcohol. Anything 000 is a negative for alcohol. So that's all I use to use to confirm it.
if it is positive, I'm just, man.
We'll talk about it when we cross that road. Okay. But
I will have somebody pick me up right now.
Okay. Well, that's not
I will leave.
one thing at a time, right? This is what we're talking about right now. All right. It's yes or no. That's all I need. Do you want to provide a breath sample? It's voluntary. I'd already told you that. I'm not trying to force you into anything. It's voluntary.
I don't know. I don't know.
If you say no, I'm just going to move on with my investigation. It has nothing to do with it. Okay. It's just one. The eye test, the walk and turn, the one leg stand. It's all. And this is just all tools that I use in my investigation. Okay. You can say no to it. It's okay. It's not going to hurt my feelings.
I don't.
Okay. Yes or no? Do you want to do it?
Can you be honest with me? Is it in my best interest? I don't know.
I'm not allowed to make that decision for you. That's your decision. I can only allow you to give the opportunity to do this. That's all it is. That's all it is. I'm being honest with you. It's a yes or no. It's voluntary. All I use it for positive reading for alcohol. This isn't the state test. This is a roadside test. Okay?
Could I please?
I'll show it to you if you want me to.
That's not, can I please have somebody just come pick me up?
Well, we're not there yet.
Okay.
I gotta finish my investigation. This is one of the last things, okay?
Okay.
You wanna do it?
I don't know.
Okay. Don't worry about it. I'll just move on, okay?
We're not doing this to spite people, for everybody's safety. I understand that's the bottom line.
What is
I
it?
have somebody pick me up.
Thomas, right?
Yes, sir.
All right, Thomas. Based on my knowledge, training, experience, you have odor of alcohol, strong odor of alcohol, bloodshot, watery eyes, and based on what I observed in my evaluations, I do determine you are under the influence of alcohol. So I need to place you under arrest. Put your hands behind your back, okay?
Sir, please.
May the record reflect that this video was paused at 13 minutes and 14 seconds. And I believe for the purposes of this hearing, as we've narrowed the issues, we don't need to see any more video in this case. Officer Postma, did you go directly to the scene of this traffic stop immediately once you were called?
Yes, as soon as I was requested, I was within the city limits and made my way directly there.
Okay, and did you make any stops or anything on the way?
No, sir.
Okay, and would you agree that this video represents the entirety of your interaction with Mr. Wallet that evening?
To my recollection, yes.
Okay, and so you were able to determine within about 13 minutes of arriving on scene that Mr. Wallet needed to be placed under arrest for DUI?
After concluding my investigation, yes.
Okay. And just one more time, please, would you restate your probable cause for this arrest?
Based off of the reason for the stop by Officer Coelho, stopping past the bulk line into an intersection on a red light. My observations out there with the defendant, I apologize if I mispronounced the name, Willett, with the manifestations of the red watery eyes, the odor of alcohol, and the conclusion of all three batteries of my the SFST evaluations.
And after you placed Mr. Wallet under arrest, did y'all search the passenger compartment of his vehicle?
Yes.
And did you find anything notable inside of his vehicle?
Yes, there was an open container of I believe it was a liquor. I don't think we were able to determine. It was not beer, but it was a liquor. It smelled like a liquor.
That's all for direct, Your Honor.
Cross?
Thank you, Your Honor. Good morning, Deputy Postman.
Morning, sir.
Let's start out by talking about your training and experience.
Okay.
You testified you're post-certified, right?
Yes.
That gives you authority and power to make arrests in the state of Georgia, correct?
Yes.
Also gives you authority to conduct stops of individuals, correct?
Mhm.
And just for purposes, I don't mean to be nitpicky, just for the record,
Oh, I'm sorry. Yes, sir. You're good.
It's okay. It's all right. I had a habit of that myself. Gives you authority to give people lawful commands, and if they refuse those commands, it could be obstruction for that person, right?
It could be.
Could be. And your first law enforcement job was Alpharetta and then Lumpkin and then Hall County?
Incorrect. I began my career in Logan County. I believe my post record says DeKalb, but accepted the position with Logan County. I never worked for DeKalb according to my post history. It was just a conditional job offer. Started a career in Lumpkin County, then went to Alpharetta, went back to Lumpkin County. Now I'm with Hall County.
Okay, thank you for clarifying that. And then when did you become post certified?
Believe at the end of 2014, was post certified deputy.
And to become post certified, you have to go through that basic mandate training. It's like 400+ hours of training, right?
Correct.
And during that basic mandate training, that's when you get your very first dose of some DUI training, about 24 hours worth.
I'm not sure if I can't recall if it was during how much detail we went through on basic. I know I went through the SFST class after it.
You would have got your first dose of DUI, some training in basic mandate, right?
Again, yes. Again, I don't know how in depth. I don't recall how in depth it was.
Okay. And after you became post certified, you mentioned that's when you got certification. I know certification, use the word loosely. It's some type of formal training on the standardized field sobriety test, correct?
Correct.
And you're trained under a NHTSA manual, correct?
Correct.
That stands for National Highway Traffic Safety Administration, correct?
Yes, sir.
And the NHTSA manual sets forth guidelines for you as an officer so you can conduct these DUI investigations generally, right?
Yes.
It also gives you specific details about field sobriety tests and the ways in which to conduct those evaluations, correct?
Yes.
And these tests are standardized, meaning they have to be done the same way each time. So you as the officer can get consistent results, correct?
Yes, sir.
And if you were to deviate from these standardized procedures, it can compromise the usefulness of the test, correct?
I don't, yes, I guess.
It could compromise the usefulness of the test, right?
I don't have that answer, but I'm trained to the standard. And it's
Right, but like if you have these standard procedures, and if you were to deviate from or depart from those procedures, it could compromise the usefulness of the test.
I'm trained to the NHTSA standard.
Is there, things that you can do as an officer where maybe if you, let's say, for example, for HGM, you have to position the stimulus, right?
Yes.
12 to 15 inches from the face, slightly above eye level, right?
Yes.
Let's just say an officer, not necessarily you, but an officer holds the stimulus way above the person's head. That could be the type of thing where you would deviate from the standard procedures, right?
That would not be the NHTSA standard.
Right. And then that's the type of thing that could compromise the test, those types of deviations, correct?
Objection. I believe we're getting into some speculation here, Your Honor.
I'm gonna allow it.
There's things an officer can do to deviate from the standard procedures that could compromise the test, correct?
I believe so, yeah.
That'd be fair to say, right?
Yes.
And you also received A-RIDE training. Do you remember when you got that A-RIDE certification?
It was in 2017.
And A-RIDE, that's Advanced Roadside Impairment Driving Enforcement?
Yes.
And it's during that, how long is that class, if you recall?
I don't recall. I believe it was possibly 2 days.
And you were, learn more about the specifics of DUI investigations?
It was primarily focused with DUI drugs.
DUI drugs, okay. And that's also different from becoming a full-blown drug recognition expert, correct?
It's the step down before that.
And, you at any point in time, you never suspected Mr. Wallet of being under the influence of drugs during this investigation, correct?
No, sir.
So let's get to February 25th, 2020. Do you remember the details of this? Did you ever think about the case after the event?
No, sir.
And, at points you had to refresh your recollection using your report, correct?
I did.
And had you had the chance to watch the video before today, prior to the hearing?
I was emailed a link to the body camera video and reviewed it.
Now, you mentioned that, let's talk about DUI investigations generally. There's 3 basic phases to a DUI investigation, correct?
Yes.
First phase is that vehicle in motion phase, correct?
Correct.
That's where an officer gets to make observations about a vehicle and its driving mannerisms and whether the driving mannerisms would lead an officer to believe the person driving might be under the influence of alcohol or drugs, correct?
Mm-hmm. Yes, sir.
So second phase, personal contact, right?
Yes, sir.
That's where you as the officer get to make observations about the person and their mannerisms, any physical manifestations that might lead you as an officer to believe the person might be under the influence, correct?
Yes.
And then lastly, pre-arrest screening. That's the third phase where you get to use those tools at your disposal, those field sobriety tests and a portable breath test to conduct the evaluation and make a determination, correct?
Correct.
All right, so let's start with this first phase, vehicle in motion. You didn't conduct the traffic stop of Mr. Wallet, correct?
No, sir. I was requested to after
And
that.
we understand the testimony is Officer Colello conducted the stop, right?
Correct.
And for Madam Court Reporter, would you agree just the spelling is Colello from your recollection?
Yes, I believe so.
Okay, and so Officer Colello conducts the traffic stop for his observations, correct?
Yes.
And you didn't arrive until after the fact, correct?
Yes.
By the time you arrive, Officer Colello's, we saw him out of the car, Mr. Wallet's out of the car, correct?
Correct.
So you can't, I mean, personally, you don't know if Mr. Wallet actually did commit a traffic violation, correct? You just were relying on what Officer Colello told you, correct?
On that fact, yes.
And you don't know, I mean, we know what time you might have been dispatched, but you don't know what time the traffic violation, alleged traffic violation occurred, correct?
Not the exact, not without going back to that history.
And same thing for when the actual stop occurred, correct?
Correct.
And, you know, because you arrive after the fact, you don't know what any of the conversation was between Officer Colello and Mr. Wallet.
Just what I was briefed on when I arrived on scene.
Only what he told you after the fact, right?
And then my conversation with Mr. Willett before.
Right.
Fields.
But you don't know the exact words that were exchanged between Mr. Wallet and Officer Colello, correct?
No, I can't speak on that.
Same thing for anything that was done by Officer Colello. You don't know if he administered any tests or, applied any physical force to Mr. Wallet.
None was advised, or I was not given any information of that.
You don't know if Officer Colello, told Mr. Wallet any information about the field sobriety tests or told him he was if he might have been detained or under arrest. You don't know because you weren't there, correct?
Correct.
And we don't know how long of a period of time between when Mr. Wallet was stopped and when you had arrived. We don't know that exact time, correct?
I mean, you'd have to go back and refer to the CAD history. Off the top of my head, I don't know.
And, presumably, Officer Colello, he conducts the traffic stop to your knowledge, right? And then has some type of interaction with Mr. Wallet, correct?
Yes.
And at some point, we assume based on the video that he's out of the car when you arrive, right?
He was out of the car when I arrived, yes.
I mean, would it be fair to assume that Officer Colello had asked Mr. Wallet to exit the car at some point?
Yes.
You mentioned that because you have trained a higher degree of training and experience in DUI investigations, maybe than some other officers you were working with in Alpharetta at the time, right?
Yes, that'd be fair to say.
And you mentioned that you would sometimes get called out to help officers who conduct traffic stops and maybe they have suspicion the person's DUI, right?
If our DUI unit wasn't working, then yes.
And you also mentioned that, some officers just don't like doing DUI investigations, right?
Yeah. Yes.
They're technical in nature. They require some training and experience, right?
Yes.
And you weren't sure exactly why Officer Colello had called you to the scene, correct?
Correct. I know he was a newer officer. I'm not sure if he had the training for it or not.
Okay. Now, we talked about some of the things that Officer Colello might have done. What about, there's certain things that we don't know what Officer Colello was not doing, right? When he was at the scene, we don't know if he was sitting in his car, just, checking the sports sheets, or we don't know what he wasn't doing to further the investigation.
Objection to speculation.
Well, he doesn't know, so.
Do you happen, obviously you're there after the fact, and I'll try to manage this question the best I can, but because you weren't there, you don't know what it is Officer Colello did, right?
Right.
And we don't know what he didn't do, correct?
Correct.
We don't know how Officer Colello had moved the ball forward in conducting this investigation, correct?
I don't recall.
Do you know if Officer Colello had collected Mr. Wallet's car keys?
Not that I know of.
Do you know if he ever told him he was free to leave or not free to leave?
Not that I would assume since it was still an ongoing investigation, it was conducted part of the traffic stop. So,
And basically, is it fair to say that Mr. Wallet has to wait for your arrival, right?
correct.
And when you arrive on scene, I mean, if Mr. Wallet just tried to say, okay, see you guys later, and then started walking away, you wouldn't be free to do that, correct?
It was a brief detention for the traffic stop, yes.
All right, let's talk about specifics. Your observations when you arrive on scene, move past Officer Colello. When you arrive on scene, you talked about some of the observations you made of Mr. Wallet, right?
Yes.
You mentioned that he had watery red eyes, correct?
Watery or glossy, yes.
And you'd be fair to say that according to your training and your experience, people who have red, glossy, bloodshot, watery eyes, that can be an indicator of the possibility of alcohol consumption or drug consumption, correct?
Yes.
You'd also agree that there's a whole host of reasons a person can have red, watery, bloodshot eyes that's independent from alcohol or drug consumption, correct?
Correct. That's why it's used with the totality of everything.
Right. Yep. Totality of the circumstances, that what you use in making the arrest. And we'll go through each part of it. But for the eyes, in and of itself, it doesn't tell you much, right?
It would be an indicator of possible impairment.
Possible impairment. Let's talk about odor. You mentioned odor of alcohol, right? You detected the odor of alcohol coming from his person, correct?
While standing there speaking with him, yes.
Now, odor in and of itself, it doesn't tell you when the person drank, right?
Correct.
Doesn't tell you what type of alcohol the person drank.
Correct.
Over what period of time.
Correct.
Or how much they had, right?
Right.
Just tells you at some point someone had something to drink, right?
Correct.
But also you learned through the course of your investigation that Mr. Olet was at the Jekyll Brewing Company, correct?
Yes.
He actually works there, correct?
Yes.
And he had told you that while he was at work, he had consumed some alcohol. And then I think he mentioned your testimony was 2 12-ounce beers, correct?
That's what he told me, yes.
And then you encounter him after the fact, right?
Yes.
Did you ever ask him, how long ago those 2 12-ounce beers were?
Do you mind if I refer real quick? I believe I have noted my report.
Yeah, if you just noted in your report, just let me know.
So I asked him what all he had to drink. He said two 12-ounce beers, and it was with a period of approximately an hour at the stop.
About an hour before the stop. Did you ask what kind of beer?
I did not.
You would agree that did you ask him what his job title was at the brewery? If he maybe works as a busboy, or if he works in the kitchen, or a waiter of any kind?
I don't believe I did.
Would you agree that a person who works at a brewery, they might come into physical contact with alcohol?
A high likely.
And if a person comes into physical contact with alcohol, they could have an odor of alcohol on their person?
It's a high probability that, yes.
You would also agree that under your training and experience that, there's how a person communicates with you, that can be an indicator of possible impairment by alcohol, correct?
Yes.
If a person is saying something inconsistent or incoherent, those are the types of communication issues that can lead you as an officer to believe possible impairment by alcohol, right?
Yes.
And you had the opportunity to speak with Mr. Wallet throughout the course of the investigation, right?
Yes, sir.
You would agree that, in seeing the video, he didn't have any of those issues and inconsistencies or being incoherent, correct?
I didn't note any.
And similarly, we have slow, slurred speech. Those are the types of things you look for as an officer to make a decision about whether a person might be under the influence of alcohol, correct?
One of many, yes.
And you would agree that, throughout your investigation, Mr. Wallet never exhibited any slow or slurred speech, correct?
I didn't notate any.
And if you had observed that, that's something you would have noted in your report, correct?
Correct.
And your report's there to be fully and accurately written,
Yes.
containing all significant and material information?
To the best of my knowledge, yes.
And you wrote your report in accordance with your training?
Yes.
There's no mention of any slow or slurred speech, correct?
I didn't notate it.
Let's talk about his walking as well. Throughout the investigation, you had Mr. Wallet move from certain locations to locations, maybe for field sobriety, or talk to him over here and do different things, right?
Yes.
And you would agree that under your training and experience, one thing you're looking for is how someone might move around about the scene, if they're stumbling, if they're swaying, or they're staggering, correct?
Yes.
Mr. Wallet never had any of those issues when walking around the scene, correct?
I didn't notate any. No.
And if you had, that's something significant and material would have been in your report, correct?
Correct.
Other things you look for, maybe how someone hands over their driver's license or how they exit the car, correct?
It would be if I was the initial officer, yes.
But you weren't there to observe those things, correct?
Correct.
All right, let's talk about this third phase of the investigation, pre-arrest screening, these field sobriety tests. You testified that of the types of tests you had Mr. Wallet perform, right?
Yes.
You testified to those results, correct?
Yes.
Where your interpretation of was from his performance, correct?
Correct.
Let's talk about walk and turn. You testified that you observed 3 out of a possible 8 clues on the walk and turn test, correct?
Yes.
All right. And you would agree that if a person, let's just say, takes a perfect 9 steps down, does a perfect turn, and does a perfect 8 steps back, and on their very last step, they misheel the toe by greater than a ½ inch, they step off the line and they raise their arm greater than 6 inches, that would be 3 out of 8 possible clues in that situation, correct?
Could be.
Because those are 3 standardized clues, correct?
Yes.
Just one moment, Your Honor. At some point, we saw during the investigation, I think it was right before walk and turn, you asked Mr. Wallet about his shoes and his footwear regarding walk and turn, right?
Yes.
Because as an officer, you want to make sure the person's got proper footwear or they're comfortable to do these types of tests, right?
Yes.
And we saw Mr. Wallet actually bend down to either remove his shoes or tie his shoes or do something, correct?
Yes.
And in bending over at the hip, he never had any issues with balance or any swaying, correct?
I didn't notate any.
And at some point, we heard Mr. Olet mention wanting to, either get a ride out of there, correct? Something to that effect.
It's my recollection after reviewing the video.
And then you had responded by saying, well, I've got to, make sure you're okay to drive, correct?
I was still conducting my investigation.
Signaling to him that he wasn't free to leave this encounter, correct?
We were still under the traffic stop, yes.
Then we heard some discussion about portable breath tests, correct?
Yes.
And you had requested Mr. Wallet to submit to this portable breath test, presumably an Alka-Sensor device.
Yes,
And you explained to him they're voluntary, correct?
I did.
And that's the true nature of these tests. They are voluntary, correct?
Everything's, yeah, I'll be voluntary. Yes.
You guys had a discussion back and forth, correct?
He made a comment that he'd been through this before, and so I was trying to bring that anxiety level down and be forthcoming about everything I was doing with him. And so, yes, I was.
And ultimately, he didn't respond, so you just took it as a, I guess you have to take it as a refusal, correct?
I logged it as a refusal, just I didn't want to keep pressing the issue, so I just moved forward with my investigation.
I want to ask you about these open containers that you located. We didn't see during any of the video that was presented today, you manipulating or holding any open containers.
Correct. The video, we don't see it in the video, is after that took place after the video had stopped, after the arrest had been concluded, the search incident to arrest.
Okay. I know it was February of 2020, but you don't recall the weather that day, correct? Whether it was hot, whether it was cold, or somewhere in between?
Not without reviewing.
Okay. Do you recall if at any point in time you documented pouring any liquid out of any cup?
It would have been on the video if it continued.
And you mentioned that it was, from your review, it appeared to be liquor. Was it mixed with anything, or was it straight liquor under your training and experience? You recall?
I don't recall. I just, after reviewing the video prior to this hearing, watched our reactions to myself and Officer Colello's reaction to smelling it. I have to refer back to my report real quick. If you don't mind, see if I notated it, but.
All right. Just one moment, Your Honor. All right. Nothing further, Your Honor.
Any redirect?
No, Your Honor. This witness may be excused.
Okay, thank you. We appreciate it. Call your next witness.
The state rests.
Anything, counsel?
No witnesses from defense, Your Honor, just arguing when the court's ready.
Okay.
Thank you. Although, how can I get this Exhibit 1 to Miss Greenhouse, Your Honor?
We'll get it to her.
Yeah, and I'll give it to DeAndre.
Okay, and the state would reserve argument.
Thank you, Your Honor. So I will go ahead and address the issues in the turn that I initially raised them. And, before I even get into the issues, I think there's a couple of issues that came up that were really interesting to me. And I've been trying to do a better job of this as a lawyer, really listening for these things, because I hear them done in every single motions hearing. I know Mr. Birch is a young lawyer like me, but we're all held to the same standard. And interestingly, during the course of the motions hearing, I don't believe Deputy Postma ever identified Mr. Roulette in court today as the same person who was out on the scene with him. There was no, let the record show that the witness has identified the defendant in this case. And similarly, I don't think venue was ever established, that this incident actually occurred within the city limits of the county limits of Fulton County. The only thing that was mentioned was During the test, I took notes on this, is that Deputy Postma said he went directly to the scene from the dispatch call within the city limits. Well, what city? That's the only evidence that I had heard about any type of venue. So something I've been really trying to listen for, and I wanted to bring to the court's attention that just wasn't introduced during the hearing. But getting to the very first issue that I raised, whether there was reasonable articulable suspicion to justify the continued detention of Mr. Wallet. The state bears the burden of proving facts that establish a basis for continued detention. That cites to Watts, WATTS versus State, 334 Georgia Appeals 770 at page 778, a 2015 case. A seizure that is lawful at its inception can violate the Fourth Amendment if its manner of execution unreasonably infringes interests protected by the Constitution. That cites to Illinois versus Caballes, CABALLES, 543 US 405 at page 407, a 2005 case. To be valid, an investigative stop of a vehicle must be brief and limited in time to that minimally necessary to investigate the allegation, invoking suspicion, and limited in scope to identification and limited questioning reasonably related to the circumstances that justified the initiation of the momentary stop. Duncan versus State, DUNCAN, 331 Georgia Appeals, 254 at pages 255 to 256, 2015 case. Additionally, it is well settled that if the officer continues to detain the subject after the conclusion of the traffic stop and interrogates him or seeks to consent to search without reasonable suspicion of criminal activity, the officer has exceeded the scope of a permissible investigation of the traffic stop. That cites back to Duncan. Here's the problem for the state, is that we've got Deputy Postma. I appreciate him being here, but that's not who they needed to be here to satisfy this issue. Officer Colello is the one who's needed to be here to satisfy this issue. Deputy Postma, all he knows is when I got dispatched for a supposed traffic violation. When I arrived, Mr. Willett and Deputy or Officer Colello are already out of the car, and I got some limited information that I might need to know to conduct my investigation. But what occurred between Officer Colello and Mr. Willett? We don't know. We don't know, and it's the state's burden at the motions hearing to show, Your Honor, by preponderance of the evidence, but still their burden to show, Your Honor, that Officer Colello had a sufficient legal basis to continue to detain Mr. Willett for after the conclusion of the traffic stop, and if they interrogate him or to seek his consent to search without reasonable suspicion, the officer exceeds the scope of that permissible investigation. We don't know what Officer Colello did, what he said, what he didn't do, what he didn't say, what threats were made, what he said about field sobriety tests or his detention. It's a gigantic chunk of evidence that's needed to satisfy this issue that the state has not submitted to Your Honor. State has not met their burden at all on that issue. For the same reason, the state fails on the second issue. Whether law enforcement diligently and expeditiously pursued the mission of the traffic stop, thereby creating an unlawfully prolonged detention. In the context of a traffic stop, a Fourth Amendment violation occurs when a police officer extends a traffic stop beyond the mission of the stop without reasonable articulable suspicion of other crimes. Rodriguez, RODRIGUEZ versus United States, 575 US 348, 2015. If an officer can complete traffic-based inquiries expeditiously, then that is the amount of time reasonably required to complete the stop's mission. Citing back to the Illinois versus Caballes case. A traffic stop prolonged beyond that point is unlawful. And there's a whole host of cases, and even one from our law office, the Hill case, where if the police act outside the scope of the mission of a traffic stop, even for a delay of a period of 10 to 25 seconds. This is an unlawfully prolonged detention. And in the Hill case, it was an officer who conducts a traffic stop, and then the officer goes outside the scope of that and asks about general criminal activity and whether there are drugs in the car. Well, they needed individualized reasonable suspicion to do that. So the 10 to 15-second delay, the Court of Appeals said that was unlawful. And I think dozens of ounces of cocaine got suppressed as a result. So that's the Hill case from our office. The same rules apply here. What is it Officer Colello was doing during the traffic stop? We don't know what time the stop occurred. We know roughly when Officer Postma arrived, but we know nothing about in between. The state has not met their burden on this issue at all. What occurred during the initial stop? Was Officer Colello actively and expeditiously pursuing the initial mission of the stop, which is the alleged failing to obey traffic control device and stopping beyond the bulk line? Was he? I don't know. We don't know. We can't know based on the lack of evidence. So for the same reasons as the first issue, state can't meet their burden on the second issue. Third issue, whether HGN was performed in substantial compliance under Towsley, that's State versus Towsley, Tousley, 271, Georgia Appeals, 874 at page 876, a 2005 case. That borrows from, our Harper standard. I think under the new Daubert standard, maybe Towsley's in question. If we can still rely on that, that's a separate discussion. But we're looking at whether the person performing the test substantially performed the scientific procedure in an acceptable manner, and we look at the sufficiency of the training, officer experience in administering, whether the test was administered following standardized techniques, and whether they were interpreted correctly. I'll concede that Deputy Postma, he's well-trained, he's got experience in administering the tests, but there was no evidence. And the court was probably surprised I didn't even ask any questions about HGN. The reason is because we didn't get any testimony about what the standardized procedures were for conducting the tests and whether he interpreted those correctly. All we heard was that he's trained and here's the results. That's really all the testimony Your Honor got. We didn't hear any testimony on direct that it was done consistent with his training or consistent with his experience as a law enforcement officer, or even what these results indicate. And I know Your Honor's handled many of these DUI hearings, and I know we all understand what clues are and what the amount of clues are, but looking at a case-by-case basis, coming into each case with a clean slate, there's no evidence what these clues even mean. Why should we care what 6 out of 6 is to the officer if he can't tell us what those things mean? So there's just missing evidence, and the state has not met their burden under the Towsley case that this was done in a substantially compliant manner with the training. Moving on to the next issue. The custodial statements in response to police questioning without Miranda. This goes back to the issues 1 and 2 where Officer Colello, we don't know what was done, what was said. State's got the burden of showing Your Honor that law enforcement did not place Mr. Wallet in a custodial situation, which is either actual arrest, actual physical control, or facts and circumstances that would lead a reasonable person to believe they're not free to terminate the encounter. Well, there's, again, huge chunk missing from the initial stop. And then even when Deputy Postma arrives on scene, I mean, he's got Mr. Wallet's been out of the car, 2 law enforcement officers at night, and then he's told at least at one time expressly he's not free to leave the scene. That's late. I'm arguing to Your Honor that custody occurred much earlier during this missing period where Officer Colello was conducting his investigation, but at the next phase during Deputy Postma's interaction would be at that point, and then finally we have the obvious, the actual physical control. But it's our position that the state has the burden of showing custody didn't occur throughout the investigation, and they just can't meet that burden during Officer Colello, where Officer Colello should have been here to testify. Next, we have the issue of probable cause. I know the court's very familiar with the rules on probable cause. I'll spare you those, but there are a couple cases I wanted to point out to the court where our Court of Appeals had reversed a trial court that found there was sufficient evidence to arrest for DUI, sufficient probable cause. And then the Court of Appeals said, no, we reverse that. There's insufficient evidence. I know you probably, I've had judges say, well, I don't care where they've affirmed trial court saying there wasn't enough evidence. So I found these ones where Court of Appeals is reversed. That's State versus Handley, Handley, 294 Georgia Appeals, 236, 2008 case. State versus Batty, Batty, 259 Georgia Appeals, 431, 2003. State versus Shaheed, Shaheed, 270 Georgia Appeals, 709, 2004. And State versus Ojemuyiwa, Ojemuyuyiwa, trouble reading my own note. It's either 265 or 285, Georgia Appeals 236, 2007. And all these cases basically say the same thing, that odor of alcohol in and of itself, insufficient. We all know that's the rule. Mere presence of alcohol, insufficient to convict for DUI. And then just because a person drinks and drives doesn't mean they're necessarily under the influence of alcohol. And the officer pretty much summarized his totality of the circumstances. Reason for the stop, which was communicated through a third party, Officer Colello, which the deputy wasn't there to witness. Observations, eyes and odor, which you heard me on cross discuss. And then the field sobriety tests, which we know really nothing about the meaning of the results in this hearing and what it meant for, or what the results indicate and what the training was and the mechanics of the test. So I would submit to Your Honor that based on the evidence presented, even on a somewhat lower standard for probable cause by preponderance of the evidence, state hasn't met their burden on probable cause. And then moving into the next issue, we discussed 702 in Daubert, that's to be reserved for a later date. And the refusal to submit to a portable breath test. Your Honor heard some, saw a video of it. I would ask the court to not consider the refusal or portions of the video that discuss the refusal. We know we had stipulated that that refusal is inadmissible and that the ultimate refusal to submit to a chemical test of his breath under the implied consent warning would not be admissible under Elliott. So for those reasons, I would ask Your Honor to grant our motions. State has the burden at motions. I think they should have had Officer Colello here to discuss this initial stop and meet their burden. So for those reasons, I ask you to grant our motions.
Thank you, Mr. Birch.
Thank you, Your Honor. I'll just go through the issues as I have them laid out here. As for reasonable articulable suspicion, I once again will rely upon the collective knowledge doctrine as outlined in State versus Pennyman 248, Georgia Appeals 446. And that's where they tell us reasonable suspicion for a traffic stop may exist based on collective knowledge of police when there's reliable communication between officer supplying that information and the officer acting on that information. In this case today, you actually saw a conversation take place when Officer Postma arrived on scene with Officer Colello, telling him the exact reason for the traffic stop, which was the red light violation. And that was actually charged as count one in this case, failure to obey, or I might have my counts mixed up, but failure to obey was charged in this case. As for the whether or not a traffic stop as far as a red light violation goes and how that might contribute to a reasonable articulable suspicion, the Georgia Court of Appeals tells us in Steinberg versus State 286, Georgia Appeals 417, a stop of a vehicle is authorized merely if an officer observed a traffic offense. And I would submit to you that a red light violation is certainly a traffic offense. As to the length of the detention, this traffic stop occurred at 11 o'clock at night. Now, we all know, Atlanta has a lot of traffic at certain times out of the day. However, at 11 o'clock at night, you can get around Metro Atlanta pretty easily. And so the Georgia Court of Appeals told us in Aldridge versus State, 237, Georgia Appeals, 2019, 45 to 50 minutes was not considered an unreasonable delay and did not convert the investigation into a custodial situation. That's specifically talking about requesting a DUI investigator to come respond to a traffic stop that was made by a different officer. And so, Your Honor, the state would contend to you that you can get across Fulton County, the entirety of Fulton County, in less than 45 to 50 minutes at 11 o'clock at night. And the timeliness of this detention, as far as waiting for Officer Postma to arrive and conduct the DUI investigation, in and of itself, did not constitute or did not qualify as a constitutional violation and did not escalate this traffic stop into a custodial situation. As for the HGN test, Towsley, which was referenced by opposing counsel, gives us a 4-part test. First of all, the officer was sufficiently trained to give the test. Officer Postma testified on direct that he was trained at standardized field sobriety testing as well as A-RIDE, and the state would contend that Officer Postma was sufficiently trained. The second prong of the Towsley test is that the officer is experienced in administering the test. Officer Postma testified on direct that he's done DUI investigation hundreds of times, and so the state would contend that Officer Postma is experienced in administering all field sobriety examinations. The third prong is whether the officer administered the test according to standard techniques. Now, opposing counsel actually brought up the NHTSA standard as part of his cross-examination in reference to the conducting of field sobriety examinations, and Officer Postma acknowledged that the standard that they're trained upon at SFST as well as during A-RIDE is the NHTSA standard, and that is the way that he's been trained. And then the fourth prong is whether the officer scored or interpreted the test properly. And he did walk you through his process of scoring each of these field sobriety examinations while he was on direct. And it's important to note that he told you on direct that the HGN scored a 6 out of 6 possible clues. Every single clue was there when he conducted this HGN test. And the Georgia Court of Appeals tells us in Civ King versus State 220, Georgia Appeals 218, a score of 4 out of 6 clues on an HGN test constitutes evidence of impairment. And so simply based upon the HGN examination alone, we have evidence of impairment as it relates to this investigation and probable cause. Now, the Georgia Court of Appeals has acknowledged that HGN testing may or may not always be performed exactly as was intended. And they tell us in Hawkins versus State 223, Georgia Appeals 34, clearly HGN testing, although far from a complex procedure, may be subject to human error in its administration or interpretation. However, such potential for error does not impact on the validity of the HGN test. No procedures are infallible. And I would tell you that any error in the administration of any of these standardized field sobriety testing should go to the weight of the evidence and not their admissibility. As far as the converting of this stop into a custodial situation and a potential Miranda violation, the Georgia Supreme Court tells us in State versus Turnquest 305, Georgia 758, Miranda warnings are not required when conducting a DUI investigation. And I think that's very clear that this, at no point did this traffic stop escalate into a custodial situation up until the point where Mr. Wallette was placed under arrest for DUI, as you saw on the body-worn camera footage. And for the ultimate issue of probable cause, I believe the state contends that probable cause existed based upon the defendant's admittance to drinking 2 beers within an hour of being pulled over for the traffic violation. Now, Hughes versus State, 296 Georgia 744 tells us the standard is whether a reasonable officer could, under the totality of the facts and circumstances, conclude the possibility of driving under the influence at the time of the incident. Probable cause is established even if reasonable officers can draw mixed conclusions. Now, in this case, we have 2 officers who both believe that this is a DUI. Officer Colello believed it so simply based upon the knowledge that we have that he called a trained DUI investigator to the scene of the accident, or excuse me, incident. And Officer Postma believes that this was a DUI, that there was probable cause for DUI here based upon his knowledge and training, his observations, and the way that he conducted the field sobriety examinations on that night. So based upon the testimony that you've heard today, as well as the arguments that were made, the state would ask you to deny the defense motion. Thank you, Your Honor.
All right, I'll take it under advisement, and I'll issue a written order. If you all want to send me certain sites that you want to highlight, I'm happy to get those from you. I've taken down as many as I could, but if you want to send them to me, I'm happy to look at what you send me. Okay.
Any particular deadline on that, Your Honor, to send?
As soon as you can, by the end of the week.
Yes,
We'll do the end of the week a good time, and I'll issue an order first of next week.
Thank you, Your Honor. And one last thing before we go.
Okay.
I just wanted to just make sure I'm totally understanding the state in their regarding their 404B 417 motion. Initially, I was going to ask Your Honor to just deny the motion, but I understand the state's withdrawing it. I just want to make sure it's on the record and totally clear and expressed that when the state's withdrawing their motion for 404B 417, that if Mr. Birch, hopefully not, but if you ever were to be replaced by a new assistant solicitor, that the solicitor's office doesn't try to bring these motions forward for Your Honor, in front of Your Honor. I think if they're withdrawing it, and that's the end of it. That's what I would ask. The understanding I'm looking for.
Mr. Birch.
I can't speak on what another prosecutor would do in this case, Your Honor.
Then I think the issue, that's what I was fearful of. And I would actually ask the court to, because we're here for motions, defense motions, state motions, to deny state's motions on 404B 417.
I'm not sure how I can deny something that I haven't even haven't heard, and that's being withdrawn. So if they withdraw them, then there's nothing for me to hear. If I deny them the ability to withdraw them, then
Your Honor, the state believes that the defendant's criminal history will always be relevant in a case. Also, there were statements made by the defendant on video that he had participated in something like this investigation in the past. And although the state is withdrawing these motions, I don't think it would be fair to the state to forecast what may or may not happen in the future.
I think there's a distinction though. Previously, we had been here for motions. State moved to continue based on the unavailability of Officer Postma. Court granted that continuance, but also state had on the same calendar 404B 417 where Officer Head and the Gwinnett County officer were unavailable, and they were also continued. So I think that if they're allowed to just withdraw the motion and then refile it at a later date, we're basically just giving them another continuance on that motion for 404B 417. They've got the burden on that issue. We're here for motions today. I just don't, and I know it's the requirements aren't the same for, motion to suppress has to be filed within 10 days after the arraignment. And I believe the rules for the 404B 417, it's at least 10 days before trial, if I'm not mistaken. I might be butchering the rule there, but Solicitor Riser was the initial one to file these motions. They've been filed, I think they were filed last year sometime. I just don't, that is what I was fearful of, is the state just saying, oh, we'll withdraw these motions because we don't, we're not going to go forward on them today. We don't have any witnesses today. And then just bring them right back when these witnesses are now available, whether it's through Mr. Birch or some other solicitor in the solicitor's office. That's just what I'm fearful of. And that's what I was assuming we were here today to argue, is defense motions and state motions. So.
Okay, well, we can't argue something that's not before me. If they've withdrawn the motions, then there's nothing for me to consider. If they do try to file the motions again, then you'll have your argument at that time. It'll be in front of me, and I'll consider it at that time, if that happens. I mean, I'm trying to anticipate something that I don't know. I mean, there's a good faith withdrawal. I have not heard that they're withdrawing the motions because they don't have anybody here to testify regarding the motions. I'm not sure why the motions are being withdrawn. But if they do try to file them again in the past, you've got me. You can make your argument at that point in time.
Thank you. And I would just like, for the record, just the state to express why they're withdrawing their motions. And I think Your Honor understands the, the concerns I was having over that. If I were to withdraw my motions to suppress, then I don't think I could bring them back up.
Right, I understand. But if that happens, then you bring it to me, okay?
Yes, Your Honor.
Okay. Let's see. Anything further on this matter this afternoon?
No, Your Honor. Thank you.
All right. May the deputy be
You may be excused. Thank you.
We appreciate you being here. Thank you. If you'll get me whatever you want to get me to consider by the end of the week, I'm happy to consider it before making a written ruling. And otherwise, I guess you all are free to go.
Thank you.
All right. Have a good day.
Your Honor, I believe we have a plea for position 5 on today's motions calendar. So if you're, please
Okay.
take that at this time.
Yes.
I get you to sign there, and then I had Anna sign as the suspended license.
Do you know if it's gonna be there?
I went to Judge Porter's for him to get the paperwork, so now.
Oh, okay, very good.
We're on paper, not on computer.
You already did that.
Oh,
I got everything all set.
but it is, it's still on.
I'm gonna need to see it on the first conviction. Y'all, I'll give you these license.
I just got. I got you.
Thank you. I gave you that one.
Let me know when you're ready, Mr. Birch.
Yes, Your Honor, I'm ready to proceed.
Okay.
Yeah, and this will be the state of Georgia versus William Moore, case number 21 CR 005732E. We've reached a negotiated agreement to this case. The defense has agreed to plead guilty to DUI less safe.
Yes.
And the conditions for that will be 12 months probation, alcohol, drug evaluation and treatment, risk reduction, 1 victim impact panel, a $300 fine, and 40 hours community service, and all other counts will merge.
Okay, I don't see the, maybe I'm missing it, but I don't see the less safe. Would you all like me to include that
You
here?
can, I just wrote DUI
Just
under
wrote DUI.
charges, DUI.
Be more specific. Do you want me to?
You can write less safe. It doesn't make a difference, but that's fine.
Okay.
Either way.
Yes, good afternoon, Mr. Morgan. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you. Anything further, counsel?
No, Judge, that we've gone over his rights. We had a chance outside. The officer was able to pull up the video, which we saw corroborated the case. With no video, we would have tried this thing 7 days a week. But with the video, it corroborates that there's a substantial basis of fact for the plea. First time he's ever been in trouble. We just asked the court to accept the plea. And I've turned in his driver's license, and we'd asked for a first conviction affidavit and that probation non-report once he finishes everything he's done. We're supposed to do.
Any objection to non-reporting?
No objection, Your Honor.
Mr. Moore, it's my understanding that in case 21 CR 005732E, you wish to plead guilty to DUI less safe. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this afternoon?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, correct.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Once you complete the terms, it'll go to a non-reporting status, which means that the sooner you get it done, the sooner you won't have to be on reporting probation, and the sooner you won't have to pay those fees. If we haven't already, we'll give you where you need to report to probation. I'll ask that you do that within the first 2 weeks or so, okay?
Okay.
All right, if nothing further, good luck to you, sir.
Judge, may we report by phone or mail? He's been working in Maryland.
Okay.
So if we just put on the
That's
sentence.
fine with
report
me.
by
You'll
phone.
just you'll have to work that out with probation, but it's fine with the court.
Perfect.
Okay.
It's just as long as it's on the sentence, they don't give them a hard time.
Okay. Let's see. And if you'll get me the rest of the paperwork, I'll get it signed.
Oh, okay. So you should.
Mr. Birch, I don't know, since we're here, if, are you with me this afternoon?
Well,
If those are moving forward or not?
I am gonna be here, but none of the ones that I've been assigned are moving forward. I believe that Mr. Charles is the only one who has, the case against Jordan Charles is the only one that may be moving forward today.
Okay, so, the first case is, Raphael Adams.
Yeah, I believe we'll be able to reach a negotiated resolution in that
Okay.
case.
And you just don't know about, the Jordan Charles case?
That's correct.
Okay, I just wanted to plan my afternoon.
Mhm.
Okay, anything further for this morning? If not, I'll see you all back at 1:30. Okay,
Thank you.
thank you. Thank you, Ms. Greenhouse.
Thank you, Judge Morrow. May I just
Okay.
ask a question of Mr. Birch?
Yes.
Yes.
Mr. Birch, you were asking about getting me that video, and I'm
Yes.
wondering, would you want to hang on to it for now? And like, I'm wondering if you're going to need it possibly.
Well, I have a copy of it available. I mean, it's not my only copy. That's just the copy for the court.
Okay.
Yes.
Okay, I understand. All right. Very good. I guess, I suppose you could give it to the litigation manager and I could be in touch with the litigation manager, Mr.
That
Randolph.
sounds great. We'll do that.
Okay, very good. Thank you.
All right, thank you.
Thank you.